ಬಂದಿದ್ದಾರೆ ಅಂತ ಕನ್ಫರ್ಮ್ ಮಾಡ್ಕೊಂಡು ಇವ್ರಿಗೆ ಹೇಳಿ. Any memos? Any adjournment? List 1, page 5, serial number 16 to 21.
After I went out, I think serious government taken time to get it voted today. Serious of course, is not
Preemptory order.
Submission made not touch now. I will not object to that. Let him go ahead. But I object to adjournment. There is an interim order 6 years, PA case 480.
No, no. Let it come. Wait for some.
Page 6, serial number 22 to 25.
Okay.
24 is it?
24 minutes. And
Then it comes up for respondent number 2, please for time. To file a statement of objection. This time, next.
List 1, page 1, serial number 1.
Please, my lords.
Serial number?
For the petition. Serial number 5 is it? Please for time. Next.
List 1, page 1, serial number 1, Venkatesh Somareddy, Praveen S.
Your Lordship, if I make a mention, serial number 20, Your Lordship. The matter
Which
is
list?
first list, Your Lordship, is in the final hearing.
Yes.
A connected matter is pending before the Supreme Court, Your Lordship,
No, you have
which has
to-
a bearing on this matter. In the last occasion also, I've mentioned the same, that the matter has pertinent bearing on the Supreme Court matter has a pertinent bearing on this matter, Your Lordship. Therefore, this matter might kindly be adjourned.
Let me see. Let it come. I'll look into the order sheet and then pass orders. Next.
Much obliged.
May please, my lord.
Which one? No, there is application is pending. You have to address arguments. Not necessary. Now we are enjoying the benefit of the interim order and that is objected to. An application seeking vacating is filed. Come when it is, wait for some time. Yes, serial number 1.
Please, my lord, yesterday's matter for being spoken to. It appears, my lord, sir, after he gave the undertaking or he was purged of the contempt, my lords, and contempt proceedings were dropped by the honorable coordinate bench, my lords. There he was in the office of that post, my lords, in charge of this case only for some time, my lords. Then it was entrusted to somebody else.
Yes.
So the fact remains, my lords, as far as that aspect, as your lords observed, my lords, that he had given that statement, my lords, and honorable coordinate bench closed the proceedings at that stage, my lords.
Yes.
And moreover, my lords,
Yes.
now they have concerned, now pursuant to my lord's order, DCP has taken over, and yesterday he was arrested and accused were arrested and produced, my lords.
Yes. So you have no objection to.
Please, no objection, my lord, please. No objection, my lords, for being spoken, because my lord's order was communicated, my lords, as reflected in the net, communicated as it is. And because of that, my lords, they have now executed the warrant.
Let him finish.
Yes.
Please.
Finding
the report for having executed the NBW, my lord, and also a letter stating that the file has been transferred to your DCP, my lord. The further investigation will be taken up by the.
I feel if they submit, my lord, the correct date, my lords, when the concerned ACP, my lord, had handed over the charge to somebody else, my lords, that would bear
That is
the,
pursuant to the directions.
please, that this is pursuant to my lord. Earlier, the concerned ACP, my lords, after he submitted his apology, my lords, I am told that he was transferred.
Yes, application. only that. Third one, the HCGP for respondent number. Respondent state, Leonard, senior advocate for the petition. On IA-1 of 2025 filed by the state under section 528 of BNSS, seeking to expunge the directions given to DG and IGP to initiate disciplinary action inquiry against the investigating officer in the case. At the time of hearing the application, my attention was drawn to the order sheet dated 8/9/2022, wherein the coordinate bench of this court has taken into consideration the conduct of the investigating officer in not executing the NBW, showing the accused as absconding in the charge sheet while making submission before this court that the very same accused are appearing before him, cooperating in investigation, but nothing material is found to apprehend them. However, when the same was objected to by the learned counsel for the petitioner, as the submission was inconsistent with the materials on record, the officer concerned has filed his explanation, intended unconditional apology, which is extracted in the order dated 8/9/2022. Owing to the said explanation, so offered, the coordinate bench of this court accepted the unconditional apology and the explanation and directed to drop further proceedings against him. However, he was cautioned not to repeat such things in future. The developments in the matter during investigation and immediately thereafter, highlighting the conduct of the investigating officer, forced this court to direct DG IGP to initiate departmental inquiry against him, against the investigating officer, in the light of the discussions held in the order. However, it is unfortunate to state that the order dated 8/9/2022 refer to a wherein the coordinate bench has already accepted the explanation and the unconditional apology tendered by the investigating officer, directed dropping of further proceedings against him, or by the learned HCGP who represented the state on that day, which resulted in issuing such a direction to the DG IGP. Next. Now the learned senior advocate for the petitioner has submitted that pursuant to the order passed by this court, the NBWs which were pending were executed and the accused were apprehended. And further investigation and the HCGP filed a memo stating that the NBW as per the direction of this court is already executed, and the investigation and as per the direction of this court, further investigation is undertaken by the DCP, Central Division, Bengaluru City, as per the order passed by DGIGP. In view of the above, I am of the opinion that the application IA-1 of 2025 filed by the state seeking to expunge the direction to initiate disciplinary inquiry against the then investigating officer is liable to be expunged. The reasons assigned for issuing such a direction in the body of the order also requires to be modified. Hence, IA is allowed. IA-1 of 2025 is allowed. Office is directed to carry out necessary modification as per the direction of this court. Upload the modified operative portion of the order as well as the entire text of the order in the website and communicate the same to the DGIGP. Yes. IA is allowed.
Please.
Communicate the order. Yes.
Grateful.
ಆಗಿದೆ ಅಪ್ಲೋಡ್ ಅಂತಾನು ಹೇಳಿದೀನಿ, ಕಮ್ಯುನಿಕೇಟ್ ಅಂತಾನು ಹೇಳಿ. Yes.
Serial number 2 for reporting settlement, Satish K, J. Somshekhar, P. Mahesh, K. S. Malikarjunaya.
Within my party, I have no instruction, whatever they have reported, I have no instruction, ultimately issued a notice, registered notice, is present before this report. There are no, I shall not given any instruction to report any settlement.
But the fact remains that in the compromise decrees passed in OS 596. No, that was recorded in the order sheet. Pass over. Why should I, sir? You are representing the party. Why should I venture to such? No, nothing. Nothing. I have recorded his submission on the last date of hearing. At your instance, it is posted today. It is your duty. I cannot assume your role. I am not going to inquire the party. Why should I do that? No. Pass over. Please, see, anyhow the party is present before the court. Please inquire and apprise her about the contents of the order sheet, past order sheet. Thereafter, I'll take up. No doubt. Next. ಎಲ್ಲದು ಪಾಸ್ ಓವರ್ ಆಗಿದೆ ಸರ್. ಪೀಸ್ ಮಿಲ್ ಅಲ್ಲಿ ಅಡ್ಜೆಂಟ್ ಮಾಡಲ್ಲ. All the 7 matters are passed over. All connected 7 matters. Next.
Serial number 3 for orders, S.M. Kulkarni.
2018 matter, madam. Kodi order sheet. Interim order ಅನ್ನೋದು. ಇಲ್ಲ. Counsel for the petitioner prays for time to furnish PF with correct address of the respondent for issuance of notice. The notice issued earlier to the respondent returned unserved as the respondent is in abroad. Even though more than 6 years have elapsed, the petitioner is not diligent in prosecuting the petition. What is the stage before the trial court? HCGP, please note this.
Private party.
Yes, what is the stage? Petitioner is directed to furnish the present stage of the criminal proceedings before the trial court, up to date. List finally as a last chance. Finally posted, you have to furnish the present status of the criminal case before the trial court and take steps. Next.
Serial number 4, Lakshmikant K. BB Patil.
Counsel for the petitioner filed a memo seeking withdrawal of the petition. Memo is placed on record, petition dismissed as withdrawn. Next.
Serial number 5, Nandakumar BL.
I appear for petition, my lords.
Yes.
Well, I'll do the needful in a week's time.
Counsel for the petitioner prays for a week's time to do the needful. Office as a raised objection for non-payment of PF, that is stamp and foreign acknowledgement. Petition is of the year 2022. List finally as a last chance. It is posted finally, sir. Please.
Oblige,
do the
oblige,
needful.
my lord, oblige.
Yes. Next.
Serial number 6, inter-alia, H. Bhagwan, Mithil.
Here, Mr. Sridhar is it? Learned Counsel Shri Sridhar NG filed the memo seeking permission to retire from the case on behalf of the petitioner. In the meantime, Learned Counsel Shri S.G. Bhagwan filed wakalat for the petitioner. Hence, Shri Sridhar NG, Learned Counsel, is permitted to retire. Office is directed to delete his name in the cause list and show and vide. So. ಏನಿದೆ ಆರ್ಡರ್ ಶೀಟ್ ಕೊಡಿ. When will you argue the matter on merits?
2 weeks. Yes, 498. This is also 498. I need to produce the certified copy of that. And also the charge sheet statements of not produced by the earlier counsel.
I'm not concerned about that. You can produce whatever you want and get ready to address the argument. No further extension of interim order or adjournment. Counsel for the petitioner undertakes to praise for time and undertakes to address argument on the next date of hearing without fail. Submission is placed on record, list finally as a last chance. Next.
Serial number 7, Jayanta Pujari.
Yes, maintainability. Prime number ಬೇರೆ ಅಂತಾರಲ್ಲ. Very good. Pass over. ಏನಿದೆ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ.
Serial number 8, party in person, K. Sambashivan, S.Y. Shivalli.
ಅಪ್ಲೋಡ್ ಆಗಿದೆ. ಅದ್ರ previous ಆಗಿದೆ ಅಪ್ಲೋಡ್ ಆಗಿದೆ. 14%, the petitioner party in person is absent or representing. Even on the last date of hearing, the petitioner was absent. It is stated that the order sheet dated 25/11/2024. It is stated. The order sheet dated 25/11/2024 reads as under. It is stated that this order sheet is already uploaded in the website. In spite of that, the petitioner is absent. The petition is of the year 2021. Needful is not done pursuant to the office objections. It appears the petitioner is not interested in prosecuting the petition, hence petition dismissed. Next.
Serial number 9, Asim Malik.
Body order sheet. Counsel for the petitioner prays for time. The petition is of the year 2022. Petitioner is enjoying the benefit of the interim order. IA-1 of 2023 is filed seeking vacating of the stay. Under such circumstances, I do not find any reason to adjourn the matter. Next paragraph. When counsel for the petitioner undertakes to address the arguments and merits, submission is placed on record. List for admission. There. List for admission along with IA-1 of 2023. Get ready to address arguments and merits on the next date of it.
Serial number 10, Venkatesh Sarbati.
That's bad on merits argument.
I will serve.
Admission ಮಾಡಲಿ ಅವರು grounds ಮಾಡು.
Serve ಮಾಡ್ತೀನಿ.
ಸುಮ್ನೆ notice ಹಾಕಿ they have to pay the fees. Copy served.
My lord,
Copy is already served.
we will serve today, my lord.
You argue on merits. Counsel for the petitioner prays for time. Petition is of the year 2022. Petitioner is enjoying the benefit of the interim order. In the meantime, the state has filed IA-1 of 2023 seeking vacating of the state. The counsel for the petitioner undertakes to address the arguments on merits instead of addressing the argument on the application. Submission is placed on record. List for admission. On admission, merits argument. Yes. Next.
Serial number 11, Parvez Ahmad.
Next week ಬರ್ತದೆ. ಕೊಡ್ತೀನಿ ನಾವು ಅದರಲ್ಲಿ ಏನು.
Give the date. How it is connected?
The same,
Different crime number?
no, the same crime number.
No. Why he has filed two petitions?
But firstly, I have filed a petition for the mother and father.
Hmm.
Thereafter, the son, we have filed a separate petition.
Then how can it be the same accused filing two petitions?
No, it is not the same, there are three accused.
No, just now you said same accused, same crime number.
Same crime number.
Hmm.
The same crime number.
That is why I said,
That is husband case.
It is the same crime number.
that is fine.
TRLP,
But when you say same accused, same crime number, there cannot be.
same crime number, different crime. TRLP 938.
Kodi. Burford. When counsel for the petitioner submits that so and so is connected with the present petition, which is filed by the co-accused, and the same may be tagged with the present petition. Office is directed to verify and list the same along with the present petition. Survival. Office is directed to show the name of the learned counsel representing respondent. Interim order extended list. ಅದಕ್ಕಿಂತ ಮೊದಲು list ಅನ್ನೋದನ್ನ the counsel for the petitioner and respondents are directed to address their arguments on merits on the next date of hearing without fail. You get ready on merits. I will hear you on the next date of hearing. I will
On
hear
merits,
you
sir.
on merits on the next date of hearing. Huh? Yes, but
On the 6th of February for here.
the sixth may not be possible.
Doing the other one.
Maybe I have ordered for listing along with this petition. ಆಯ್ತು ಅದು ಎಲ್ಲಿಗಾದ್ರೂ
The
ಮಾಡಲಿ.
date has been, so the final hearing is that.
ಬೇಡ ಬೇಡ six.
That is the date.
Hmm.
The hearing is being posted on that.
Then this matter will be posted along with that.
Yes, on the 6th.
ಅದು ಅಲ್ಲಿ ಇದು ಈ ರೀತಿ ತಗೊಳ್ಳಿ.
14.
ಎಲ್ಲಿ ಬರೀ? Then counsel for the petitioner submits that criminal petition number so and so is connected with the present petition is filed by the co-accused. Office is directed to list the present petition along with so and so and post it before the appropriate bench. Yes,
Number 12.
appropriate bench, it will be posted. Both the cases, interim order, you have to extend.
12, Mahesh Kiran Shetty, CS Satish.
IA is filed for vacating by the
Counsel for the petitioner, pays for time. The petition is of the year 2022. Petitioner is enjoying the benefit of the interim order. The state has filed IA-1 of 2023 seeking vacating of the interim order. In spite of that, the counsel for the petitioner is not ready to address the argument. The next, when a counsel for the petitioner undertakes to address the arguments on merits, date of hearing, submission is placed on record. List for admission finally as a last. On merits, next date of hearing, we should get ready. Yes, no further extension. Yes. Next.
Serial number 13, Monica Patil.
Whether you serve the copy on the other side? Can the production be dispensed with? No objection. Heard learned counsel for the petitioner and respondent on IA-1 of 2025, filed by the petitioner seeking dispensation from producing. You are seeking dispensation from producing the typed copies. Dispensation from producing typed copy of annexure A. And counsel for respondent has no objection. For the reasons stated in the so and so affidavit or memo on note. IA-1 of 2025 is allowed. Production of typed copy of annexure A is dispensed with. Let's start. Interim order extend ಮಾಡಿ. Next date of hearing, you address the arguments on merits. I thought, and in the meantime, you do whatever you want. Both the learned counsel undertake to address their arguments on merits on the next date of hearing without fail. Submission is placed on record. List finally, as a last chance, interim order is extended. Yes.
Serial number 14, Lata Shetty, Francis Xavier.
For the writing and the work by PA.
Mm. You know what is that? Statement of objection? Hmm.
Not stated anything, my lord, their only contention is that is the authorized disseminate.
I too, I will hear you on merits, please. Hmm. 1 minute.
What are 73?
Why there are two petitions? Why there? Same accused?
notify directly to the complaint. Page 39.
Two complaints,
Two.
similar complaint, similar complaints. Yes.
Subject and notice page 39.
Hmm. In 1971,
1973.
okay,
Is number 39.
yes,
The notice will find. The notice will reading the denial will that the cost type. The cost type will be at page 32. Subject would notice. Rule number 1 is the complaint. 4, 5, 6, 7, 8, 9, 10. I am 10. Have been arrayed as an accused.
A2 to
18 to 8.
A2 alla, 10
2 are under the purported
directors. All the directors are accused.
that's what makes fees.
Hmm.
That the fee.
So,
Yes, that's all.
previous one.
Yes,
And exact conflict you are talking about is 39, the key.
yes,
Complainant permission after the return of our object, the complainant will put a statutory notice. So what can be agreed? The accused person and part of the permission, so that is the next step.
Hmm.
Office copy of the legal notice, the next step, which is the. Anyway, duly served on that, office copy of the legal notice is produced as a copy of the. Despite receipt of the legal notice, the accused did not follow, complainant should be acted as a no entire hands are open today. So nowhere is there any amendments which refers to the requirements of 141. And compared to what my lawyer has been also made. Notice saying to the 138, we only not 141.
that is addressed to all the accused. Next, real. All the accused.
Not the necessary amendments in the. Now this law is settled the law.
Yes. Yes,
I am not certain.
that is the only ground.
That is one. The latest decision from the.
Similar is the fact in the connected matter.
Public notice is the judgment that Sheila Padmavati Amma. Elder were on the Supreme Court of 1924. The relevant paragraphs would come from paragraph 8 onwards. Again, the order of the law will find page 10. That I wrong. This is culminating in the middle. You could have this is the dispute as simply because the person is a direct requirements of the one of that. Does it help that the person cannot pay like a sometimes that is like for the charge of the case of this one that to make it but this was a director then there is the so then the clearly the director of the necessary to avoid how the director of the how the want to clarify. The position of a managing director is not managing director, maybe different. This would help that means for the
Party.
they will have to put that on the other. And they have to put the they will have to- They are very careful to keep the word of the section without the statement of how and what manner the director would not refer by the director. Then referring to all other judgments, they are taking a word your honor.
Open ಮಾಡಿ.
That. 90, that it is the only allegation given that just for just avoid that. There's no argument to the effect that the present appellant is charged of and responsible for the case. You know, the government has not completed the case. I'm not even a director. Then it was to the supermarketing came about that was March.
Which is the paragraph?
There are 33 onward, last but one case.
Yes.
Surveillance of reliance on the judgment in Anita Hada is necessary for law. But this case is understood the necessity of involving the company as an exclusive. It does not support the extension of liability for authority to the judgment over lays down that the director of authority would come under the arbiter of power for the purpose of 43A. The appellant's misinterpretation completes the role of authority in the employer because distinct under the act. Appellants have relied on a single paragraph which does not form part of the right to pay. But in this relied upon paragraph, court only made an observation that an authorized signature is of the law for the company for the legal purposes of entity. The respondents correctly argued that an authorized signature is not a draw of the check as a here. This judgment clarifies that the signature is the mere authorized to sign on behalf of the company and does not require a draw. The respondents interpretation aligns with the penal strictly particularly in the judgment and take it Abuja further support in the conclusion by court issues or the principle of the state. This is based on like the legislative state and every time we go around the company. The company management is likely to only under specific conditions provided under 141. What we could notice that in the entire company, no such thing required at the moment. Prima facie on the face of it.
Yes.
And I'm instructed to draw attention on this before. That the coordinate bench with respect to the same matter I already emphasized the proceedings.
I thought the Supreme Court decision.
They were not the director at the time of issuance of the checks. That is the form number.
No, where is the allegation, sir?
35, I will come to.
So my humble submission here, Your Honor, is that I was not a director.
Your accused number
I have to number 10.
in both the cases?
I have only authorized signature.
In both the cases, your accused number.
Other case accused number.
Number.
In 10 in which case?
10 in the present matter, Your Honor. 70.
11 in the other matter. You are not the director.
And even that government is not available. My humble submission that this would be very low. Coordinate with
Coordinate bench in particular. Why you are relying on this?
For the reason
Hmm.
that they were not directors at the time, they were in that paragraph.
Have you produced any document? Have you produced any document to show that you are not the director?
Yeah.
Which compilation, sir?
It's a-
Page number?
157.
What is this?
I am not, nowhere knows my name.
No, what is the document?
This is the annual report filed with our. This is the 14 to 15. Who is in the, either in the note 20, the name of the related party. Nowhere do I.
This is the year which is dated, this, no, register, this ROC, ಏನಿದು? Annual report is for the year 14-15. Annexure, what is the annexure? Where are the names of the directors? No, it is at page number 128, it seems.
Yeah, those are only concerned persons for nine this. I have a incorrect to say that this would be the.
No, but the list of directors is not found. Then,
Get the extract of the figures from now.
yes. It may not help you.
It will not show my name.
Yes.
That's what I.
No, you could have produced that straight away to buttress your contention.
Even as of now,
Mm.
even as of now, we are for that. We are so.
It is there. Of course, you could have made the job of the court easy. Then,
I agree. But I come as a respected, as inspected. with our reviews. But be there for them.
yes, what do you say?
My lord, in this case, my lord, the argument of the senior counsel is that, my lord, section 141 is not attractive
Hmm.
as far as like permitted to address the things. Similar facts.
Hmm.
The argument of the permit counsel is that the ingredients of section 141 is not attractive. I am permitted to read section 141.
Not developed, not attracted.
Not covered. Then I will permitted to.
Admittedly, there is no averments in the complaint.
I will go to the complaints. go to the complaint straight away, take my lord to the complaint, my lord, my complaint. In page number 1971. In page number 31,
1973 ಇಷ್ಟೊತ್ತು ಅವ್ರು ರೆಫರ್ ಮಾಡಿದ್ರು.
1973.
Yes.
1973. My lord, he has omitted the para 4 and para 5 of the governments in the complaint. My lord, I am permitted to take my lord to para 4 and para 5 in page number 36. In page number 36.
Yes.
My complaint.
Yes.
The first accused is the public limited company incorporated under the provisions of the Companies Act, so on so. The accused number 1 is the managing director. The accused number 2 to 9 are the directors. The accused number 11 is the authorized signatory of the accused number 1 company. That is para 4. My lord, I will take my lord to para 5, my lord. Para 5 of the complaint. The complainant submits that the accused number 2 to 10 are being the managing director, authorized signatory of the accused number 1, are actively involved into day-to-day business affairs and financial transaction of the accused number 1 company. My lord, I will take to para. Para 7.
Yes.
The accused number 2 to 10 in the capacity of the managing director, and authorized signatory of the accused number 1 company, and on behalf of the accused number 1, have executed necessary papers, documents, and agreements in favor of the complainant bank in relation to SBLC facilities for an amount of USD 10 million provided by the complainant company. The facilities agreement, so on so. Then, my lord, I will straight away take my lord to para.
Just now you read which paragraph?
Para 7. Para 7. And my lord, I will skip para 8, 9, 10. I will take my lord to para 11. Para 11. Para 11.
Yes.
That pursuant to the facilities agreement and the letter dated 27/8/2014, that is 2014, my lord, and against the facilities award, the accused persons have agreed to reduce the facilities towards the discharge of the liability, legally enforceable debts. The accused number 1, represented by accused number 2 to 10, have issued a check bearing number 60, 62, so and so, 31/5, and assures of his realization. The copy of the check 60, 62, 22, dated 31/3/25 for rupees 6 crores 10 lakhs drawn on United Bank of India Electricity Bank at Bangalore is produced at marked as an XJ. I may be permitted to refer one documents in this. They produced the documents, my lord, the letter issued the 27/8. That is not the documents, my lord. My lord, this letter, my lord, I am permitted to read the letter, my lord. This letter to ICICI Bank, 27, at my complaint, we have it. With reference to the credit arrangement letter dated 27/8/2014, letter August 27/8/2014, the facility so and so. Pursuant to the facilities agreement and the letter dated 27/8/2014, we have agreed to reduce the SPLC facilities in the manner as follows. There they have given the breakups. So and so. Next, my lord, last paragraph, my lord, I will take my lord to last paragraph. In consideration of the aforesaid premises, we enclose checks bearing check number 60, 62, 22, 60, 22, 3, 60, 62, 24, 60, 22, 5, and 60, 22, 26, and 60, 22, 27 drawn on United Bank of India Electronic City branch in your favor, duly signed by us. We hereby specifically irrevocably agree and confirm that we shall have full authority to deposit the aforementioned post-dated checks and present the checks towards the reduction of the SPLC facilities. We ensure that the aforesaid checks shall be honored on such presentation. My lord, this letter has been signed by the petitioner. My lord, when this letter has been signed by the petitioner, they cannot say that he has not involved in the day-to-day affairs of the company. That is what my complaint, my lord. I have produced this letter.
Yes.
Along with my complaint, in order to contend that para 4, 5, 6, 7 of the complaint, we clearly stated that the accused number 1, represented by accused number 2 to 10, are actively involved in day-to-day affairs and business transaction of the company.
Yes.
And my lord, further, my lord, in this letter, further support my case that this letter itself is issued by the petitioner, that is the who is the accused number 10 in this matter. My lord, he is aware of the day-to-day affairs of the company. He is involved into day-to-day affairs of the company. My lord, he himself has signed the checks. My lord, the checks has been signed and delivered by the accused number 10. My lord, if at all, if their argument is that the check has not been drawn by the, signed by the accused number 10, my lord, for the sake of argument that could be considered here in the case, my lord, the accused number 10, the petitioner signed the letter, delivered the check has been signed by the accused number 10 and delivered to the complainant. My lord, the board resolution, I will take my lord to the board resolution, they themselves have produced the board resolution. Connection here. In page number 140. 140, my lord. Para 3. Para 3. Para 3. Para 3, my lord.
Yes.
Para 3. Sri Vinod Ramamani, Sri Srinivas, Sri Ashwini Kemani, the director officials of the company be and hereby authorized, severally authorized to do the following acts in favor of the company. My lord, there is a board resolution. Under the board resolution, the petitioner has been authorized, my lord, to discharge certain acts and to sign certain documents and to sign the issue letters and to sign the agreements. My lord, by virtue of the board resolutions, my lord, the accused number 10, that is the petitioner, had acted upon, involved into day-to-day business affairs of the company.
Yes.
My lord, when such being the case, my lord, I have clearly narrated in my complaint that he has been involved into day-to-day affairs and financial transactions of the company and been permitted to take the legal notice in para 10, same complaint, my lord, para 13 of the complaint, we issued a legal notice to him along with the other director and the accused number 1 company. My lord, the legal notice has been served upon him. We have clearly stated that the legal notice has been served upon there. My lord, when the legal notice has been served upon there,
Yes.
my lord, he could have given the reply stating that I am not the authorized signatory, I have not been authorized, I have not involved into day-to-day and financial affairs of the first accused company, second respondent company. My lord, there is no reply as such by the accused number 10, that is the petitioner hearing. Now, my lord, now the petitioner is before this honorable court and contending that he is not a director, he is not involved into day-to-day affairs of the company. That argument cannot be considered. I am permitted to read, my lord, the relevant, the judgment to that effect, my lord. The judgment given by my learned senior counsel, my lord, to that effect, I am permitted to refer the judgment. My lord, the similar case has been considered in the by the Honorable Supreme Court, my lord, we have 2008 Supreme Court cases 2357. My lord, Para 5. We have gone through the judgment cited by the learned counsel is SMS Pharmaceuticals. My lord, I will read SMS Pharmaceuticals judgments, my lord, what Supreme Court told in this regard. My lord, I will skip. The Supreme Court has framed the 3 issues, my lord. Issue number A, whether for the purpose of section 141 of the Negotiable Instrument Act, it is sufficient if the substance of the allegation read as a word fulfill the requirements of the said section, and it is not necessary specifically state in the complaint that the person accused was in charge or responsible for the conduct of the business company. Whether the director of the company would be deemed to be in charge and person responsible to a company of conduct of the business of the company and therefore deemed to be guilty of the offence unless he proved the contrary. Even if it is said that the specific governments are necessary, whether in the absence of the such governments, the signatory of the check, my lord, here in the case, my argument is the signatory of the check and the managing director or the joint managing director who admittedly would be in charge of the company and responsible to the company for the conduct of its business would be proceeded against. Lord, I will take my lord to the issue number 6, which has been discussed in the next page, my lord. See. See,
Hmm.
the answer to the question has to be is in the affirmative. The question noted that the managing director or joint managing director or the director would be admittedly in charge of the company and responsible to the company for the conduct of its business. When is so, holder of such position is the company become liable under section 141 of the Act. By virtue of the offence, they hold as a managing director or the joint managing director. These persons are in charge and responsible for the conduct of the business of the company. Therefore, they got covered under 141. So far as the this one is very important, my lord. So far as the signatory of the check, which is dishonored, is concerned, he is clearly responsible for the incriminating act and will be covered under subsection 2 of section 141.
Yes.
My lord, my lord, the Supreme Court has come to the conclusions that, my lord, he held responsible. My lord, the next judgments, my lord, 2023, my lord, all these judgments have been referred by the Honorable Supreme Court, my lord, in page number 5. I will take my lord to para 32 of the judgments, my lord. Para 32, which is at in page number 27, trending page number 707, 27.
Page number?
Page number 27. Para 32 of the judgment.
Yes.
Evidently, a person who signs the check or who has the authority to sign the check for and on behalf of the company, regardless of his office or the capacity, can prima facie be assumed to be in charge of and responsible to the company in the conduct of its business.
Yes, God.
Conduct of its business, and where such person is prosecuted, then such person is prosecuted, then if it be his defense that the offence was committed without his or her knowledge, or that he or she has exercised all the due diligence to prevent that the commission of such offence, the burden to prove that would be on him or and can only be discharged at the stage of evidence. Not his case, because the court is not aware. He is not aware anything. The first time he has taken the defense before this honorable court, stating that he is not responsible, he is not aware of the business transaction of the first accused. Now, my lord, what Supreme Court says that, my lord, has to be decided at the time of trial whether he is liable or he is not liable.
Yes.
My lord, if the matter is pending, my lord, at the time of framing of the issues, my lord, all the other accused have been given out since the NPW was not executed. When the matter was about to post it for evidence, my lord, he is before this honorable court contending that that he is not he is a director and was resigned. He is not aware of the day-to-day affairs of the company. My lord, the Supreme Court says, as a authorized signatory, my lord, I have already demonstrated before this honorable court. As a authorized signatory, he issued a letter dated 27/8/2014, under which, my lord, several checks have been issued to me, and also assured that those checks presented will be encashed without the dishonor. My lord, further he himself has signed and delivered the check. We presented the checks, my lord. Legal notice has been issued. Legal notice has been served upon them. Despite service of the legal notice, my lord, he did not choose to give the reply. My lord, the Supreme Court says all those allegations have to be tried by the trial court. And if the best, what he can do, he can take the defense before the trial court at this stage of trial. My lord, I am permitted to take my lord.
CC is only against the present petitioner. CC is
And the company 1, 2, and 10.
1, 2, and
10.
Managing director and
Managing
the
director,
authorized.
authorized signatory. All the other directors, my lord, I will come to the judgments, my lord, coordinate bench judgments, my lord, which my senior counsel has referred, my lord, on what ground they have been discharged. 2 directors. My lord, the other directors, my lord, since the NPW was not served upon that, they have given. My lord, I will take my lord to the page number 29, my lord. In page number 29. Lord, as read by this court in Anil Alda, he referred Anil Alda. Anil Alda, the phrase as well as used in subsection 1, section 141 would avoid the person mentioned therein within the tentacle of the offence on a part with of the operating company. Therefore, the company or firm, the drawing of the check, such company or firm is the principal offender and fiction created by the legislation. When the offence is attributed to the juristic person or a body made several individual and liability to be prosecuted, so on. So punish is exempted to employ by legal fiction other human being, that the legal fiction to be interpreted and applied to the individual intended to be employed may not escape the liability here on the fact that it has not been charged. He is not been in charge at the time when one of the other events essentially completed of the offence by the company happened. My lord, that's what the Honorable Supreme Court, he cannot escape, my lord, stating that the other of the events essential to complete of the offence by the company happened. Borrowing against state Bhaskaran, the court should not adopt interpretation which helps the dishonest awarder and keeps an honest payee, as that would defeat the very purpose of legislature. My lord, I will take my lord to, again, my lord, the para 50, 51 and 57. The principle discernible from the aforesaid decision of this court in Ashuntosh Ashok Parasuram Preya, the High Court should not interfere under section 482 of the code at the instance of an accused unless it comes to across some impeachable and incontrovertible evidence to indicate that the director partner of the firm would not have been concerned with the issuance of the check. This court clarified that even in given case, despite of the presence of the basic government, the High Court may conclude no case is made out against the particular director, partner, provided director is able to adduce some unimpeachable and incontrovertible evidence beyond such suspicious and doubt. In Ganamal case, my lord, the Supreme Court therefore, the para 52, my lord, the principle laid down and dictum as laid down in Ganamal case, in our opinion, still holds the field and reflect the correct position of law. In the case on hand, we find clear and specific governments, not only in the complaint, but also in the statutory notice issued by to the respondent. There are specific governments that the check was issued with the consent of the respondent, hearing within our knowledge. In our view, it was sufficient to put the respondent hearing to the prior for the said alleged offence. We are saying so because of the case of the respondent that at the time of issuance of the check or at the time of commission of the offence, she was no manner concerned with the firm. She was not in charge or responsible for the day-to-day affairs of the firm. Cannot be accepted on the basis of the mere word assertion in this regard. The same is not sufficient. To make good her case, the respondent hearing is expected to read unimpeachable and incontrovertible evidence. Nothing sought to adduce by the respondent before the High Court to get the proceedings passed. The High Court has practically no legal basis to say the arguments made in the complaint are not sufficient to fasten the vicarious liability upon the respondent by virtue of section 141 of the Act. We may also examine the appeal. It is not in dispute as noted that no reply has been given by the respondent. My lord, is para 54, my lord. Para 54. Para 54. We may also examine that the appeal from the different angle. It is not in dispute as noted that no reply has given by the respondent to the statutory notice served on by the appellant in the proceedings of the present time, essential for the person to whom statutory notice issued under section 138 of Act to give an appropriate reply. The person concerned is expected to clarify his or her stance if the person concerned has some unimpeachable, uncontrovertible material to establish that he or she has no role to play affairs of the company, then such material should have been highlighted in the reply notice to the reply to the aforesaid notice as a foundation. If any such foundation is laid, the picture would be more clear before the eyes of the complainant. The complainant would come to know as to why the person to whom he had issued notice says he is not responsible for the dishonor of the check. I have already, my lord, argued. My government is very clear. Notice has been served. No reply has been given. The first time they have come before this honorable court. My lord, another judgments, my lord, in a similar manner. 2019, my lord, the page number 38. The Supreme Court has reiterated the judgments given by the court, and also I don't want to take much time of this honorable court come to the conclusion that the absence of the material evidence, my lord, the proceedings cannot be caused by you by exercising the rights under section 482 of the CRPs. My lord, the judgments referred by the senior counsel, my lord, in Tara, the first judgments, my lord, Susila Padmavati Amma.
Yes.
Para 20. Para 20 of the judgments.
Yes.
It can be thus clearly seen there is no averment to the effect that the present appellant is in charge and responsible for the day-to-day affairs of the company. It is also not the case of the respondent that the appellant is either the managing director or director of the company. In that concept, my lord, the judgment came to be passed. My case is, my complaint is very specific, my lord. I have clearly stated what is the role, how they are involved into day-to-day affairs of the company. My lord, the other judgments, my lord, by the senior counsel referred, my lord, see Gurudatta Sugar Marketing Private Limited Company. My lord, this judgment has been passed in the context of section 143A. My lord, the court nowhere the court says, my lord, the 143A, my lord, to pay the statutory, my lord, interim payments, that application has been made. Under the 143, my lord, the court cannot order against the authorized signatory or the company is liable, not the authorized signatory. In that, but the court never says the authorized signatory cannot be made liable for prosecution as contemplated under section 141 of the Act. If you read the judgments, my lord, the judgment has come to the conclusion that, my lord, nowhere it has stated that they are not responsible. The judgment has been passed in the context of section 143A of the Negotiable Instrument Act. That could be para 33. Para 33. The court has come to the conclusion that the order, my lord, the authorized signatory will comes under section 143A. For that, my lord, the court, the Honorable Supreme Court says that the authorized signatory will not comes under section 143A, but the prosecution under section 138 and under 141 can continue. That is the judgment delivered by the Honorable Supreme Court. Under these circumstances, my lord, there is a board resolution authorizing the petitioner to do certain act. Based on the board resolutions, my lord, the petitioner himself has issued a letter, given checks.
Yes.
And also the check has been presented, no reply has been given.
Doctor, to ask me a question initially, whether
Now he is made it clear that you are the authorized signatory. No, according to you, what is your position? And issued the check. You received the legal notice. No reply. And leave it. Not a case. Not a case.
First of all, the list of witnesses are there.
Hmm.
I'm directing the example.
Hmm.
List of that. Now you're not sure. Legal notice has been received. Proceedings have been against the 10 person.
Yes.
Against accused number 3,
Hmm.
the coordinate bench has quashed it.
Hmm.
4 to 9 has been dismissed by the trial.
They stand a different footing. Yes.
Now you are not. You have been issued with the legal notice, you have not answered, is the query of this honorable court against.
Hmm.
Now you are not sure. Proceedings have been initiated. Now the question that I would seek your lordship to appreciate is, in the context of the requirement of our issue before your lordship on the basis of which I am seeking submission before this body is that should a complaint
Yes.
make amendments or not.
Yes.
Now to that effect, I bring your lordship's attention to paragraph page of the complaint to paragraph 13 onwards. Whereas my learned friend here draws attention of this court to paragraph 4, 5 and 6.
Yes.
Your lordship. Now your lordship. In view of that, your lordship may kindly see page 35. Here let 4, 5 and 6. Page 35 of the same complaint. 4, 5, 6 was read here. We'll see a lot. Complaint under 200, read with section 138. 141 has not been invoked at all. Then similarly, paragraph 30, notice has been issued. It is only on 138, not on 141.
Yes,
They have never invoked it.
yes,
Coming to the compilation that my amendment has produced, the first one, 2008 Supreme Court 2357, at paragraph 4 thereof, on page 2,
Hmm.
the decision of the Supreme Court in SMS pharmaceutical has been there. But and on the left hand side, right hand side, bottom, on page 2,
Hmm.
is it necessary to specifically aver the complaint under 141 that at the time of open court, the person was in charge of the responsible for this government is an essential requirement of 141 and has to be made in a complaint.
yes.
That is absent in my submission report.
In para 5 is specifically stated, sir, you are the authorized signatory and actively involved in day-to-day business affairs, business financial transactions.
Then you also have to read a 13 order as no reference to 141.
Maybe, sir, in every paragraph that need not be repeated.
Same judgments.
At one place, it is stated you are the authorized signatory and you are responsible for day-to-day affairs. Is it not sufficient?
The question is, though that 143A was being highlighted that it was the context of 143A that the secretary is not. In the absence of amendment, my entire first of my submission before the court is that absence of amendment in the petition and the complaint would it meet the requirements of 141. If your lordship feel that that is not required of elsewhere in the petition, some reference is there, then I could not give.
Yes. It is sufficient. At one place, there should be reference. And each and every para, there need not be a reference to that. Yes. So, yes, yes. No, I am dismissing the petition. The petitioner in criminal petition number 1971 of 2321 being accused number 11 and petitioner in 1973 of 2021 being accused number 10 in yes. In CC number 22503 of 2015 bracket nulli arising out of PCR number 13797 of 2014 and PC number 7177 of 2015 bracket nulli PCR number 8900 of 2015 on the file of 15 respectively pending on the file of the learned 26th additional Chief Metropolitan Magistrate Bengaluru bracket nulli 26th ACMM Bengaluru is seeking to quash the criminal proceedings initiated against him. Since you are not a director, it is his contention, you are this authorized signatory. Yes, sufficient. Authorized signatory. Admittedly, you are the authorized signatory. You are liable in that capacity. Yes. Since these two petitions arise out of two different criminal cases against the petitioner, where the facts are similar, the same are taken up for disposal together under this common order. The facts of the case are that the respondent as complainant filed the private complaint against accused numbers 1 to 10, alleging that accused number 1 is the company registered under the Companies Act. Accused number 2 is the managing director. Accused number 2 other accused are the directors, and the petitioner herein being accused number 11 in 1971 of 2021 and accused number 10 in 1973 of 2021 is the authorized signatory to accused number 1. Accused number 1. It is stated that accused number 2 being the managing director, other accused being the directors or the authorized signatory were liable to pay the amount and were actively involved in the day-to-day business affairs of financial business affairs and financial transaction of accused number 1 company. And accused number and the petitioner herein as the authorized signatory issued the checks in question towards discharge of legally enforceable debt. When the checks were presented for encashment, the same were dishonored as there was insufficient fund in the account of the accused. Legal notice was issued to all the accused, informing them regarding dishonor of the check and calling upon them to pay the check amount. It is stated that the petitioner has not replied to the legal notice in spite of receipt of the same. Thus, it is the contention of the complainant that all the accused, including the petitioner, have committed the offense under section 138 of an act. Next part. On filing the private complaint, the trial court took cognizance of the offense and registered the criminal cases against the accused, including the petitioner. The petitioner is before this court seeking to quash the criminal proceedings initiated against him. Heard so and so, so and so. Read the materials, point for consideration. My answer to the above point in the negative for the following reasons. It is the contention of the learned senior advocate that 2 different criminal private complaints were came to be filed by the respondent, alleging commission of offense punishable under section 138 of an act. Similar allegations are made against the petitioner in both the complaints. The grounds urged by the learned senior advocate for quashing the criminal proceedings is that the petitioner is not the director, but he is only an employee of the company. There are no averments in the complaint to satisfy the requirement of section 141 of an act. Under such circumstances, the criminal proceedings against the petitioner is liable to be quashed. Per contrary, it is the contention of the learned counsel for the respondent that admittedly the petitioner is the authorized signatory to accused number 1, which is a company registered under the Companies Act. Accused number 2 is the managing director. In such capacity, the criminal complaints before the trial court is being prosecuted against accused number 1, the company, accused number 2, the managing director, and the present petitioner has the authorized signatory to the checks. From counsel, they abused the letter issued by the present petitioner, the content that the petitioner referring to the checks involved in these cases specifically stated that he is the authorized signatory, and in his capacity as such, he had issued the checks and he is responsible for the affairs of the company. The counsel also submits that admittedly the legal notice issued to the petitioner were served on him and there is no reply from him. Under such circumstances, The petitioner being the authorized signatory is liable for the offence and is liable for a trial for the offence under section 138 of an Act. Next part. On perusal of the materials on record, especially the private complaint filed by the respondent against the petitioner and other accused, at para 4 and 5, it is specifically stated that accused number 1 is the managing director, accused number 2 to 9 are the directors, and the present petitioner is the authorized signatory to accused number 1 company. It is also stated that accused number 2 is the managing director, other accused are the directors, and the petitioner is the authorized signatory to accused number 1, and they are actively involved into the day-to-day business affairs of the business and the financial transaction of accused number 1 company. Thereby, the complainant has pleaded about the requirement of law under section 141 of the Negotiable Instrument Act. Next, it is the specific contention of the complainant that the present petitioner, being accused number 11 in CC 1971 of 2021 and accused number 10 in 1973 of 2021, is the authorized signatory, and in such capacity, he issued the checks in question. When the counsel for the respondent has produced the letter dated 3rd September 2014, issued by the petitioner regarding declaration for post-dated checks, there is reference to as many as 6 checks issued by the petitioner six checks issued by the petitioner authorizing the complainant to present the checks for encashment and ensuring that the checks will be honored on presentation. The petitioner has also agreed that any breach or default in complying with the undertaking given in the letter will constitute a default on his part. The senior advocate for the petitioner never disputed this letter. On the other hand, it is a definite stand that the petitioner is the authorized signatory to accused number 1 company. When it comes to the senior advocate for the petitioner placed reliance on the decision of the apex court in Sushila Padma versus Bharati Airtel Limited in support of his contention that necessary ingredients in consonance with section 141 of Negotiable Instrument Act is necessary to hold that the accused is liable to the company for the conduct of its business. We have also placed reliance on the decision of the apex court in Shri Gurudatta Sugars Marketing Private Limited versus so and so, to contend that in the absence of necessary requirements to plead in the complaint to satisfy the requirement of section 141, the petitioner cannot be made liable for the offense under section 138 of an Act. He also placed reliance on the decision of the coordinate bench of this court in Shri Bhaskar Prapati versus ICICI Bank Limited to contend that under similar circumstances, the coordinate bench of this court has quashed the criminal proceedings initiated against the accused. Per contra, one counsel for respondents has placed reliance on the decisions of the apex court in Prakash P. Rajda versus State of Maharashtra and another to contend that the apex court in categorical terms held that even in the absence of any averment in the complaint, the signatory of the check and the managing director of the company who are admittedly in charge of the company are responsible to the company for conduct of its business are liable to be prosecuted under section 138 of MI. He also placed reliance on the decision of the apex court in 2023 10 SCC 685 to contend that when there are prima facie materials to support the contention of the complainant that the accused is responsible for the conduct of the business of the company, the criminal proceedings against the accused is not liable to be quashed. He also placed reliance on the decision of the apex. Next, I'm going through the materials on record. It is clear that the respondent as complainant has clearly pleaded that accused number 1 is the company, accused number 2 is the managing director, and the present petitioner is the authorized signatory. The letter produced by the learned counsel of the respondent confirms the fact that the petitioner is the authorized signatory. Interestingly, even the learned senior advocate for the petitioner is not disputing the fact that the petitioner is the authorized signatory for the company and he issued the checks in question. It is also not disputed that the petitioner has received the legal notice got issued by the complainant, and in spite of that, he has not issued any reply. When such is the case, the petitioner cannot contend that he is not liable to be prosecuted for the offense under section 138 of NI Act. Contention of the senior advocate for the petitioner that the legal notice was issued only under section 138 of NI Act and not under section 141 of NI Act will not inure to his benefit in any manner. If at all the petitioner is having any defense, he has to take it before the trial court, but he is not entitled for any relief in the present petitions. Accordingly, I answer the points in the negative and proceed to pass the following. Petition is dismissed. Petitions dismissed.
Serial number 15, Vandana PL, Keshav Kumar.
$15. Yes. That MC is already disposed of. Is this crime number? 30.
Yes.
Yes, what is it?
Amendment is admitted. There's some ideas which is still, the like including the ownership if we got to cruise.
No, what is pending?
Ideas to payment of the apartment.
Execute the decree. Execute the decree in the MC 1728.
We can avoid history of states. We requested this. One of the support coming to move because of the petition of number one.
When you sign the memorandum of settlement and agree before the trial court that the dispute between the parties is amicably settled, you should have taken care of.
The issue was this. The agreement.
Now,
was-
once you admit that there was settlement, and once you said that I am withdrawing the allegations and I will cooperate in quashing the criminal proceedings, now you cannot turn around and say, no.
Issue.
Hmm.
The beginning of the agreement was the month of October 2023. And the complaints, there were properties were supposed to transfer by taking the reverse of the time. And they're supposed to clear all the areas of property maintenance and the clubhouse and so on and so forth. That after 7 months they completed, I mean, they transferred the property money. Between those and plus those which was areas previous to this. I only come to my knowledge now. They're not allowing me to.
No, that cannot be the grounds. That cannot be the
No,
ground.
I'm not seeking-
You cannot find new grounds for prosecuting, no?
You don't. This is one of the obligation that they're supposed to complete that still.
Where it is stated in the memorandum of understanding.
Be seen.
Hmm.
Petitioner has taken loan in IDFC bank.
Petitioner means,
Petitioner is the first petitioner here.
yes,
And petitioner states in the MC. Leave petition. Against the property mentioned in para number 7, the EMR still in vogue. Petitioner has agreed to clear the entire outstanding loan in respect of the property on or before reporting this settlement and handing over the NOC and clear title deeds to the respondent.
yes.
In this.
This is not done.
No. And there is, they have taken 7 months to even complete the transfer. But
Now it is completed.
It is completed now.
Ah.
Only the arrears is come to my knowledge, because the notice have been issued to me, it also issued to him, the petition of one. He's not hearing to it. We have not made several.
Arrears of,
Arrears for the clubhouse maintenance, it's coming up to about 4 lakh.
that is not the subject matter of the memorandum of understanding.
That NOC from all the authorities, including bank, including the property, whatever the arrears.
No, that is reference to IDFC Bank.
IDFC and NOC to be handed over. It needs.
NOC is referring to IDFC Bank. What is that property?
Title deeds also minors.
Hmm.
Whatever comes as a,
There is no reference to any maintenance, payment of maintenance, areas of maintenance.
if I'm buyer, if I'm buying a property without the sellers giving me property with arrears.
Whether this memorandum of settlement is produced before the court
Yes, minors. Yes,
and MC is disposed of,
yes, it's.
then
Subsequently, the notice has come, they're not being allowing me to utilize it.
the clause says agreed to clear the entire outstanding loan in respect of said property on or before reporting the settlement.
Please.
Already reported, the settlement is already reported.
After 7 months, and there is a overdue for payments, these.
You prosecute that. No,
Then liberty.
yes, liberty will be given.
Please,
Yes,
I'll prosecute.
yes.
Let there be a liberty.
Why you are keeping that pending? Why don't you settle that? Yes.
Your Lordship, submission, there is some areas of fuel resources that is reported in the audition. Then I'm not.
All these claims should have been before the
My only issue is,
family court,
my.
in the MC,
There are.
not at this stage.
No, there is one only request is,
Hmm.
let there be a liberty reserved, if there is something that we are supposed to.
I
hear.
noted. So. Learned counsel for the petitioner filed a memo. Reducing. A copy of the hard sheet. In the MC 1728 of 2021. On the file of the learned principal judge, Family Court, Bengaluru. The decree passed therein dated 11/6/2024. The memorandum of settlement under section 89 of CPC read with rule 24 and 25 of Karnataka Civil Procedure mediation rules 2005 filed before the family court in MC 1728 of 2021 to contend that the dispute between the parties herein is amicably settled. MC was allowed, is it? Divorce is granted. MC 1728 of 2021 was allowed, and the marriage between the petitioner number 1 and respondent number 2 is dissolved by decree of divorce. Pursuant to the same, respondent number 2 has undertaken to withdraw all the allegations against the petitioners and undertaken to cooperate in quashing the criminal proceedings. Under such circumstances, she prays for allowing the petition. The counsel for respondent number 2, while entering into the memorandum of settlement under section 89 of CPC, as produced by the learned counsel for the petitioner, and also submits that also admitting that the respondent number 2 had undertaken to withdraw the allegations and cooperate in quashing the criminal proceedings, submits that pursuant to the settlement, something more is due from the petition number 1, and the same is not yet paid. Now, under such circumstances, the criminal proceedings cannot be quashed. My attention was drawn to the recitals of the memorandum of settlement, where there is reference to crime number 30 of 2022, pending before the learned first additional civil judge, senior division, Mysuru, and the order sheet of the family court in MC 1728 of 2021, where both the parties, that is petitioner number 1 and respondent number 2 hearing, admitted amicable settlement in terms of the mediation settlement report. The order sheet also discloses that the petitioner, where petition number 1 hearing had handed over the DD for his 5 crores to respondent number 2 hearing. The petitioner has also handed over the original documents of the property to the respondent. On being satisfied with the settlement arrived by the party between the parties, MC 1728 of 2021 was deemed to be allowed by accepting the mediation settlement report. Under such circumstances, as per the memorandum of settlement, respondent number 2 hearing, has undertaken to operate in closing, public quashing, crime number 30 of 2022, pending on the file of the learned first additional civil judge, senior division, Mysuru. And both the parties have agreed to withdraw all the allegations made against each other. Under such circumstances, I am of the opinion that proceedings against the petitioners is liable to be quashed. If at all, anything is due to be paid to the respondent one, she will be at liberty to execute the order passed by the family court if she is advised to do so. Accordingly, I proceed to pass the following. Petition is allowed. One kade, the memorandum of settlement filed in MC 1728 of 2021 reads as under on mail appeal. Reads as under full extract. Proceed to pass the following. Petition is allowed. Criminal proceedings, so and so quashed. Liberty is reserved with respondent number 2. Proceed against the petition. So, if advised to do so, as it is a contention, the petitioner is due to pay some certain sum of money in terms of the memorandum of settlement. Yes.
For further arguments, serial number 16, Nayak NR, Anand.
The book or landowner of the law came to be dismissed. Counterclaim has been allowed not to hinder any third party remarks. This undertaking was taken in earlier during pregnancy of the suit. Before this honorable court is not going to hinder.
1 minute. Yes, what is that?
Earlier, my lord, the 30 hours, my lord, one of the plaintiff filed a complaint before the state police stating that we have went to the house of the premise and trying to demolish the structure. And also trying to harass the tenants. All the tenants are vacated during pregnancy of the suit. Suit came to be dismissed. Suit for declaration came to be dismissed on 29/3. Later, my lord, I got the certificate copy on 12/4. On 13/4, I went near the house because they came to know the certificate copy. They got permanent injunction restraining them not to induct third party. Now this second respondent, they want to induct in the person. We have objected. Immediately he went to the police station, filed a complaint against us. That is the complaint, crime number 94, my lord. And that was also questioned before this honorable. Now it was dismissed. Now, my lord, the second complaint on 18:30 hours, matter
No,
evening.
crime number 94 is dismissed.
Yes.
Early,
ಮೊನ್ನೆ,
one agide.
Because I have cross-examined.
Yes,
Yes.
since evidence is being, yes.
Next, my lord, this complaint has been filed. No charge sheet has been filed because they are granted. Because two complaint on the same subject matter. Same, we have trespass as it like. Now in this complaint matter, so-called this second respondent, he belongs to a scheduled caste community, as if we have abused him and we are trying to obstruct him. The same type of incident, my lord, he has continued in the same police jurisdiction. That is the complaint, my lord, page number 11. Today I have placed. Page number 11.
The respondent number 2.
They are
What represent?
He's absent, man.
Third option.
Page number?
11 man. One Nanjapur filed a complaint because wherever vacant property is available, he wants to occupy matter and extract money. Para number 2 matter, ದಿನಾಂಕ 21/6/19 ಮಧ್ಯಾಹ್ನ ಈ ದಿನ ಸಂಜೆ 6 ಗಂಟೆಯ ಸಮಯದಲ್ಲಿ ಶಂಕರ್ ರೆಡ್ಡಿಯವರ ಕಡೆಯವರು ಹೇಳಿಕೊಂಡು ಬಂದು ಸಹಚರರಾದ ಮೂರ್ತಿ, ದಟ್ ಇಸ್ ಸೆಕೆಂಡ್ ರೆಸ್ಪಾಂಡೆಂಟ್, ಪ್ರಿಯ, ಇನ್ನೂ ಕೆಲವರು ನಮ್ಮ ಮನೆ ಬಳಿಗೆ ಬಂದು ಮನೆಯ ವಿಚಾರದಲ್ಲಿ ನಮ್ಮ ಮನೆ ಮೇಲೆ ಗಲಾಟೆ ಮಾಡಿ ಮನೆ ನಮಗೆ ಸೇರಬೇಕು, ನಾವು ಮನೆಯಲ್ಲಿ ಸೇರಿಕೊಳ್ಳುತ್ತೇವೆ ಎಂದು ಹೇಳುತ್ತಿದ್ದಾರೆ. ಅವರಿಗೂ ನಮಗೂ ಯಾವುದೇ ಸಂಬಂಧ ಇರೋದು, ಆದ್ದರಿಂದ ಅವರುಗಳನ್ನು ಕರೆಯಿಸಿ ಇನ್ನು ಮುಂದೆ ನಮ್ಮ ಮನೆಯ ಬಳಿ ಬರಬಾರದೆಂದು ಕಂಪ್ಲೇಂಟ್. He himself given the statement.
This is complaint by?
By one Nanjappa.
Nanjappa.
In the locality manner.
Yes.
He used to the same thing. That is the active acts of the second respondent. Because he belongs to scheduled caste, he wants to take occupy. Page number 13, my lord, he himself went to the police station. The statement has been given, I don't. Then he, ನಾನು ಮೇಲ್ಕಂಡ ವಿಳಾಸದಲ್ಲಿ ವಾಸವಾಗಿದ್ದೇನೆ, ಎಲೆಕ್ಟ್ರಿಕಲ್ ಕೆಲಸ ಮಾಡಿಕೊಂಡಿರುತ್ತೇನೆ. ಈ ದಿನ ನಾನು ಪೊಲೀಸ್ ಠಾಣೆಗೆ ಬಂದು ನಂಜಪ್ಪ ಎಂಬುವರು ನನ್ನ ಮೇಲೆ ಹಾಗೂ ಇತರರ ಮೇಲೆ ಕೊಟ್ಟಿರುವ ದೂರನ್ನು ತಿಳಿದುಕೊಂಡಿರುತ್ತೇನೆ. ಆದರೆ ನಮಗೆ ಶಂಕರ್ ರೆಡ್ಡಿ ಎಂಬುವರು ಪರಿಚಯವಿದ್ದು ಅವರು ನಮಗೆ ಕರೆದು ನನಗೆ ನಂಜಪ್ಪನವರು ಹಣ ಕೊಡಬೇಕು, ಅವರ ಮನೆಯ ಬಳಿಗೆ ಹೋಗಿ ಹಣ ಕೊಡುವಂತೆ ಕೇಳಿ, ಇಲ್ಲವಾದರೆ ಮನೆಯಲ್ಲಿ ಸೇರಿಕೊಳ್ತೇವೆ, ಆಗ ಅವರೇ ಹಣ ಕೊಡುತ್ತಾರೆ ಎಂದು ಹೇಳಿದೆ. ಅವರ ಮಾತನ್ನು ಕೇಳಿ ನಾವು ನಿನ್ನೆ ದಿನ ಈ ದಿನ ಇನ್ನೂ ಕೆಲವರು ಜೊತೆಯಲ್ಲಿ ಸೇರಿ ಶಂಕರ್ ರೆಡ್ಡಿಯವರ ಹಣವನ್ನು ಕೊಡಿ ಎಂದು ಕೇಳಿದೆವು. ಆದರೆ ನಾವು ಅವರ ಮೇಲೆ ಗಲಾಟೆ ಮಾಡಿರುವುದಿಲ್ಲ. ಶಂಕರ್ ರೆಡ್ಡಿ ಮತ್ತು ನಂಜಪ್ಪನವರ ನಡುವೆ ಹಣಕಾಸಿನ ವ್ಯವಹಾರ ಇದ್ದು ನಮಗೆ ತಿಳಿದು ಬಂದಿರುವುದರಿಂದ ಅದರ ವ್ಯವಹಾರ ಬಗೆಹರಿಸಿಕೊಳ್ಳಲಿ. ತಂದೆ ತಗರಾದ್ರೂ ಹೋಗೋದಿಲ್ಲ, ಹಾಗೇನಾದ್ರೂ ಹೋದಲ್ಲಿ ನಮ್ಮ ಮೇಲೆ ಕಾನೂನು. This is the custom they happy manner. He used to go there and trying to occupy the property. The same thing is happened in this case, manner, because all the tenants are vacated. During pendency of the suit, it has come. And also the counsel for appearing on behalf of the plaintiff.
Is it his contention? He is the one of the tenant?
No, my lord, there is no error. My humble request, I have placed one of the affidavit, my lord.
No, in the
One of
complaint, in the
Page number
complaint,
9, man. He is not a tenant.
he may not be, but whether it is his contention that he was a tenant?
He is
His contention is a tenant, man.
Page number 9.
Is there any reference to his name in the
No,
civil
no.
dispute?
Suit ಎಲ್ಲೆಲ್ಲೂ ಒಂದು word ಇಲ್ಲ. Because all other tenants they have vacated by executing the order. SRC filed eviction order I got and evicted one of them.
Any wound certificate
No.
in the present case?
He is one of the witness in another case. Second respondent in another case, crime number 92.
Yes, SCGP, is there any wound certificate?
There is no wound certificate, my lord. It is in the investigation, no, my lord. It is in the
There
crime
is
stage,
Allegation that
my lord.
ಅಲ್ಲೇ ಮಾಡಿದ್ದಾರೆ,
ಅಲ್ಲೇ ಮಾಡಿದ್ದಾರೆ.
ಆಸ್ಪತ್ರೆಗೆ ಸೇರಿಸಿದೀವಿ.
Yes, man. wound certificate ಯಾವ್ದು ಇಲ್ಲ, man. Investigation ನಡಿಬೇಕು. man.
ಏನಿಲ್ಲ,
ಅದ್ರ
prima
ಬಗ್ಗೆ.
facie abuse of process of law.
Yes,
I'll quash.
please.
Petitioner. Petitioners being accused number 1 to 4.
Yes.
Petitioners being number 1 to 4. Crime number 95 of 2019 of Madiwala Police Station, registered for the offense punishable under sections 3, 1 and 3, 10 of prevention of SC/ST prevention of atrocities Act. And under sections 424, 147, 143, 506, 506, 148, 149, 448, and 323 of IPC are seeking to quash the criminal proceedings initiated against them. Brief facts of the case are that respondent number 2 as informant filed the first information with the Madhipal police alleging that he is in occupation of a rented premises belonging to Chikkaramaya Reddy on 13/4/2019 at 6 a.m. when the informant was staying in the said house along with his family members. Case number 1 to 4 along with 30 other persons came and attacked him with the deadly weapons. They assaulted the wife of the informant, caused injuries. They abused the informant, referring to his past, and criminally intimidated to take away his life and the life of his family members. And assaulted wife and the father of the petitioner, the male guy. And thereby they have committed their offense. Accordingly, he requested the police to register the case and to initiate legal action. Accordingly, police have registered the case and took up investigation. In the meantime, the petitioners, being the case number 1 to 4, approached this court seeking to quash the criminal proceedings initiated against them. An order of interim order of stay was granted, and therefore no further investigation was undertaken. However, so and so, so and so. Here is the materials point for consideration. My answer to the above point in the affirmative for the following reasons. Respondent number 2 as complainant filed the first information with the Madiwala police against accused numbers 1 to 4 against accused number 1 and his son, alleging commission of the offense as stated above. He stated that the incident had taken place on 13/4/2019 at 6 a.m. But the first information was came to be filed on the same day at 18:30 hours. The FIR was forwarded to the learned magistrate on 15/4/2019 at 2 p.m. There is inordinate delay in forwarding the FIR to the learning magistrate. Next. Respondent number 2, even though served, remained absent. He is not contesting the petition. There is an allegation that petitioners being accused number 1 to 4, along with 30 other persons, attacked the petitioner and his family members, assaulted his wife and father, criminally intimidated to cause their death, and also abused the informant by referring to his caste with an intention to defame them. But no wound certificate appears to be issued by any of the medical officer concerning the so-called injured persons. When a counsel for the petitioner submits that in the civil proceedings pending before the petitioners, petition number 1 and the owner of the property, that is Shri Ikramai Reddy, referred to in the first information. Who filed was 7060 of 2012 against petition number 1 for declaration of his right over the property. There is no reference to the present respondent number 2 being in occupation of any portion of the building as tenant. The counterclaim is filed by petition number 1, is it? No. Counterclaim filed by
Petitioner number 1.
the counterclaim filed by petition number 1 seeking permanent injunction restraining the said Chikkarama Reddy from inducting any third party as a tenant was came to be declared. It is stated that declaring the counterclaim filed by petition number 1, the respondent but who try to take forcible possession of a portion of the property at the instance of Chikkarama Reddy and file the present complaint. The counsel for the petitioner has produced a copy of a similar complaint filed by respondent number 2 against one Shankar Reddy and others, making similar allegations. The said complaint produced as per document number 3 is dated 22/6/2019 with Madiwala Police. A non-cognizable offense a non-cognizable offense was came to be registered by Madiwala Police. Document number 5 produced by the petitioner is the statement of respondent number 2 given to Madiwala Police on 22/6/2019, according to which he was instructed by Shankar Reddy that Nanjappa is due to pay certain amount to Shankar Reddy and asked respondent number 2 to go near the house of Nanjappa and demand for payment of the amount. Pursuant to the same, he went to the house of Nanjappa and started demanding the amount and later filed the complaint. Placing reliance on these documents, the counsel for the petitioner contends that the petitioner, the respondent number 2, is in the habit of filing similar complaints only to extract money, taking advantage of the fact that he belongs to scheduled caste. Prima facie, the contention taken by the learned counsel for the petitioner is supported by materials on record. When Even though it is the contention of respondent number 2 that he was in occupation of a portion of the building as tenant, and the incident had taken place on the date and time referred to by him, in the civil suit that is OS number 7060 of 2012, there is no reference to him to be in occupation of the premises. Even though it is contended that the respondent number 2, his wife and father were assaulted by the petitioners, there are no prima facie materials for having sustained any injuries or taking treatment in any of the hospitals. Considering all these facts and circumstances, I am of the opinion that the criminal complaint was deemed to be registered by abuse of process of law by making allegations and by invoking the provisions of the SC Prevention of Atrocities Act. It is yet another classic example of misuse of the provisions of the enactment, which was enacted with the laudable object of protecting the rights of the real oppressive class in the society. Hence, I am of the opinion that the criminal proceedings against the petitioners is liable to be quashed. Accordingly, I answer the other count in the affirmative and push across the following petition is allowed. Allowed.
Serial number 17, Kamaluddin, Ashok B. Patil, connected matter Syed Kamaruddin.
Parted matter.
Serial number 18, Ramu, Venkatesh Sarbati.
ಯಾಕ್ರಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡೋದಿಲ್ಲ, ಯಾಕಷ್ಟು ಹೆಸಿಟೇಷನ್?
Education ನನಗೇನು
ಮತ್ತೆ
ಎಂಗೇಜ್ ಮಾಡೋದ್ರಿಂದ ಒಂದೇ ಒಂದು ಕಾರಣಕ್ಕೆ ನಾನು ಟೈಮ್ ಕೇಳ್ತಾ ಇದ್ದೀನಿ ಹೊರತು ಅದರ್ವೈಸ್ ಐ ಆಮ್ ಹ್ಯಾಪಿ ಟು ಆರ್ಗ್ಯೂ ದಿ ಮ್ಯಾಟರ್.
ಬಿಟ್ಬಿಡಿ, ಅವರು ಲೀವ್ ದೆಮ್ ಟು ದೇರ್ ಫೇಟ್.
So last time I made a mention, senior counsel ಈ ಟೈಪ್ ಕಾರ್ಡ್ಸ್ ಕೊಡಿ ಅಂತ ಹೇಳಿದ್ರು, ಅದಕ್ಕೋಸ್ಕರ ನಾನು ಮೆನ್ಷನ್ ಮಾಡಿದೆ. ಅಫ್ಕೋರ್ಸ್ ಎಲ್ಲರ ಫ್ರೆಂಡ್ ಮೇಡ್ ಎ ಮೆನ್ಷನ್ ಮೇಲೆ 28 ಅಂತ ಹಾಕ್ಸ್ಕೊಂಡಿದ್ದಾರೆ. ನನಗೆ ಬಂದು ಹೇಳಿದ್ರು ಅವರು, ಆಯ್ತು ಅವತ್ತು ಬಂದಾಗ ಹೇಳೋಣ ನಾವು, ಯಾಕಂದ್ರೆ ಮಾರ್ಚ್ ಫಸ್ಟ್ ವೀಕ್ ಅಂತ ಸೀನಿಯರ್
ನೀವು ಆರ್ಡರ್ ಶೀಟ್ ನೋಡಿ ಸರ್, ಆರ್ಡರ್ ಶೀಟ್ ಡೇಟೆಡ್ 7/1/2000, 7/1/16/1. ಮತ್ತೆ ಆಯ್ತು, ಐ ವಿಲ್ ರೆಕಾರ್ಡ್ ಯುವರ್ ಸಬ್ಮಿಷನ್.
ಧಾರವಾಡದಲ್ಲಿದ್ದಾರೆ ಅದಕ್ಕೋಸ್ಕರ
I will record your submission and proceed. You have made your effort. I will hear him and proceed. Nothing. Sir, senior counsel, I cannot go on adjourning the matter. No.
No, on 3/2/2024, 5 my lord, if I do not go on with the matter, my lord may not extend the interim order.
Sir, not, see 7/1, 16/1, again.
True, my lord.
No.
I'm not saying.
This is the third time you are seeking time. No.
Nothing may not extend the interim order on that day.
ಏನಿಲ್ಲ.
That's my undertaking.
Nothing.
ಯಾಕಂದ್ರೆ ಅವರು ಹೇಳಿದಾರೆ, ಅದಕ್ಕೋಸ್ಕರ ನಾನು ರಿಕ್ವೆಸ್ಟಿಂಗ್ my lord, my lord.
Sorry.
3/2
That will send a wrong signal.
So that 3/2
Simply senior counsel antkule, this court is it habit of adjourning the matter. No, I will not.
My lord may impose.
ಏನು ಮಾಡಲ್ಲ. On merits I will dispose of. Sir, yes, proceed.
Just prepared a short synopsis, 2 pages.
ಏನಿಲ್ಲ ಅದು ಆ ಹ್ಯಾಬಿಟೇ ಇಲ್ಲ ಇಲ್ಲಿ ಆರ್ಟೆಡ್ ಇಲ್ವೇ ಇಲ್ಲ. Immediately it will be disposed of. Sir, ದಯವಿಟ್ಟು ನಾನು I understood your difficulties. I am not in a position to help you in any manner. Please allow me to hear the other side. I will take your argument as nil.
Morning itself, I called my learned friend.
ಯಾವ ಡೇಟಿಗೂ nothing.
I will be
ಇಲ್ಲ,
grateful.
ಅದು ಕೊಡಲ್ಲ ಅಂತ ಹೇಳಿದ್ನಲ್ಲ. Yes.
My learned friend, my lord, morning I called my lord. In the morning itself.
Even if he says no objection, I will not adjourn. Sir. At least I have to respect my own order sheet.
No doubt.
Hmm.
ಒಂದು ಕಾರಣಕ್ಕೆ ಅದರಲ್ಲಿ
7-1, 16-1, again today.
arguing
No.
before you will ask my lord, wherever I am there you will ask.
ಅಷ್ಟೇ.
It's a one case, my lord, where I am asking time, my lord, for.
I will record. ತಗೊಂಬಿಡಿ. ತಗೊಳ್ತೀನಿ.
3-2 there.
Learned counsel, say so and so for the petitioner, praise for time.
Finally, 3-2 there.
He submits that the party is intending, no, party is intending to engage the services of the senior counsel and therefore the matter may be adjourned. Then counsel for respondent seriously opposes granting of any adjournment. The order sheet dated 6/1/2025 and 16/1/2025 reads as under. In spite of that, the counsel for the petitioner is not ready to address the argument. Simply because the petitioner intends to engage the services of senior counsel.
Week ಹಾಕ್ಸ್ಕೊಂಡೆ ಅದಕ್ಕೋಸ್ಕರ ಅವ್ರು ಹೇಳಿ ನಾನು first week
ಈಗ ಹೇಳಿದ್ರಲ್ಲ ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ನನ್ನ ಎಂಗೇಜ್ ಮಾಡ್ತಾರೆ ಅಂತ.
ಅದಲ್ಲ first week ಅವ್ರು ಇರ್ತಾರೆ ಅಂತ ಹೇಳಿ ನಾನು ತಮ್ಮನ್ನ ಹಾಕ್ಸ್ಕೊಂಡೆ ನಾನು. But in the meantime, my learned
Matter
friend,
cannot be adjourned,
got it rephoned you last. That is my responsibility.
ignoring the
Rephone
the
ಆಗಿದ್ರೆ
order sheet
ಅವ್ರು
dated
ಬರ್ತಿದ್ರು.
6/1 and 16/1/2025. Hence, the prayer of the learned counsel for the petitioner for adjournment is rejected. ಅಷ್ಟು ಅದು order sheet. Yes, proceed.
Lord, this is offense under section 13(1)(e), read with 13(2) of the Prevention of Corruption Act, Lord. Accused number 1, petitioner number 1 before my lords, the corporator of BBMP ward number 141 Azad Nagar, elected during the year 2010.
Petitioner is accused number 1.
Petitioner number 1 is accused number 1. Petitioner number 2 is the husband of accused, petitioner number 2. Petitioner number 2 is the husband of petitioner number 1. Accused number 2,
This accused number 1 is the corporator
corporator.
of ಎಲ್ಲಿದು?
Ward number 141 BBMP Azad Nagar.
Ward number 141.
Of BBMP by name Azad Nagar.
Azad Nagar.
Azad Nagar.
Yes.
But it is there in the synopsis.
Yes.
Lord, date of raid, my lord, is 9/11/2012. Date of registration of FIR is 8/11/2012.
1 minute.
May I take my lord?
Disproportionate.
My lord?
Disproportionate.
Yes, yes, DA case. 13(1)(e), read with 13(2). Check period, ಅದು ಅಲ್ಲೇ ಇದೆ. 5/4/2010 to 9/11/2012. Date of FIR, 8/11/2012, crime number so and so. Designation, that is the public servant of A1, A2. Date of raid, prosecution witnesses, my lord, 70. Along with charge sheet, my lord, 73 witnesses statements are recorded. About 272 documents in various volumes are connected and produced before the court, produced before the special court along with the charge sheet. Then, my lord, earlier round of criminal petition was filed, my lord, by the petitioners. That is also there in the synopsis in the last line of the first page. Criminal petition 6129 of 2016. My lord, the order is at page 75 along with the criminal petition. This honorable court, my lord, sent back the matter to the learned judge of the special court to reconsider the matter. Then discharge application was also filed under section 239. A detailed order, my lord, is passed. That order is not in challenge at page 83.
No, what was the order challenged in the earlier petition?
Cognizance order. Entire proceeding was challenged, but this honorable court found that the cognizance order lacks, my lord, application of mind. So, my lord, this honorable court sent the matter back to consider all contentions at the stage of discharge application. So, a discharge application was filed under section 239. A detailed order is passed at page 83. That order is not under challenge before my lords.
Order dated?
Your lordship, discharge order, my lord.
Ah.
239 order, 6/1/2018 under section 239. 6/1/2018
Hmm.
at page 83. Then, Lord, I have given a table at the next page. What is the various amounts, my lord, figures as per the source report at the time of FIR? And, my lord, what are the various amounts, not quantum, as per the charge sheet? Lord, during the source report, my lord, based on, my lord, credible information, the IO had found a percentage of disproportionate assets to be 166%. After considering all the details provided and further investigation conducted, as per the charge sheet, my lord, it was found to be 62.60%.
Yes.
Now, Lord, may I take, my lords, to page 75 and 83. Charge sheet ಇದೆ ಎಲ್ಲ ಇದೆ. ಅದನ್ನು ತೋರಿಸ್ತೀನಿ, but just, my lord, since this is second round, I'll take, my lord, what happened in the first round at page 75.
Yes.
Your lordship may kindly see at internal page 2 of the order. This criminal petition is filed under section 482 to quash the entire criminal proceedings arising out of so and so. It was after filing of charge sheet only. It was filed. Peruse the record, petition has come up with so and so. At para 6, my lord, at page 4. His lordship considered section 239. And then para 7. Even if there is no application filed by the accused for his discharge, it becomes responsibility under statutory provisions under section 239 of CRPC as noted above, that the court has to consider the police report and documents sent, and after making such examination, if any, of the accused, as the court thinks fit, and after giving prosecution and accused an opportunity, if the magistrate considers the charge against the accused, it's groundless, then he has to discharge the accused. Again, section 240 CRPC also mandates that on consideration and examination and hearing the accused and the prosecution, so on. Then, Lord, this on court found that such an examination was not there. So, Lord, para 11. In order to avoid further consumption of time, the accused petitioner is hereby directed to file necessary application before the trial court.
Yes.
Then, Lord, if such an application was filed before the trial court, then the next page, your lordship will see page 83 is the application filed and the order passed on the application for discharge. Lord, the learned judge of the special court considered, Lord, all the facts, Lord, para 1, 2, 3, 4, 5. Lord, 5 also, Lord, there is a reference to the order passed by this honorable court. Then 6, 7. At paras 13 and 14, Lord, at para 14, issue is framed. Whether the accused number 1 and 2 are made out sufficient grounds for discharge. A detailed recording of all the facts, not from para 1 to 13. Then, Lord, by assigning reasons on all the grounds that were taken, specifically, Lord, grounds in relation to section 17 PC Act, whether who has to conduct investigation, grounds in relation to, Lord, application of mind, all those aspects not considered, and the learned special judge rejected the application for discharge.
Yes.
And proceeded to frame. At that stage, my lord, this petition is filed.
Yes.
Now, my lord, the charge sheet my learned friend has produced, my lord, at page 19 onwards. FIR, my lord, is at page 30. Your lordship will get it because along with the source report. Charge sheet, my lord, I'm sorry, is at page 32. Column number 7 is there, my lord. It speaks about the disproportionate asset.
Yes.
Not list of assets and a list of witnesses are all there. At page 58, the culmination of the para 7, the conclusion of column 7 of charge sheet is at page 58. Lord, initially, my lord, I mentioned that the cognizance order was set aside. My lord, I stand corrected. It is not the cognizance order that was set aside, but this honorable court felt it, my lord, that the order relating to framing of charge was not, did not bear application of mine, so my lord, sent back.
Charge was framed.
At that stage, charge was not framed.
Then what was the order?
Not to frame charge. Because even at that stage, my lord, even I think, even the counsel for the accused said that it may proceed to frame charge. That part of the order sheet is not there. Yes, madam, I'm sorry, I stand corrected again. Page 63, charge for the offense under section so and so, PC Act and or section so and so are framed, read over and explained to A1 and A2, who pleads not guilty and claims to be tried. Page 63. Good.
Petitioners being accused number 1 and 2. In a CC number, in special CC number 18 of 2016. Technically, arising out of crime number 82 of 2012 of Karnataka Local Police. Bracket complete. For the registered for the offense punishable under section 13(1)(e) of Prevention of Corruption Act. With section 120B of IPC. Are seeking to quash the criminal proceedings initiated against them. The facts of the case are that the police inspector of Karnataka Lokaयुಕ್ta, Bengaluru, has on credible information collected the information regarding the wealth amassed, properties acquired by accused number 1, who was the elected representative, being the corporator of ward number 141 of BBMP, that is Azad Nagar, Bengaluru, in collusion with accused number 2, who is the husband of accused number 1, amassed wealth which is disproportionate to her known source of income and thereby committed the offense. As per source report, accused number 1 and 2 have amassed wealth which is 166% disproportionate to the known source of income of accused number 1. On the basis of the same, the FIR came to be registered and the investigation was undertaken. After investigation, charge sheet came to be filed, and as per charge sheet, the accused have amassed wealth disproportionate to their known source of income, and the percentage of the same is 62.60%. Therefore, it is the contention of the prosecution that the accused have committed the offense punishable under section so and so 1E, read with 13(2) of Prevention of Corruption Act. Next paragraph. The trial court took cognizance of the offense and initially framed the charge against the accused number 1 and 2 for the aforesaid offense. The petitioners have filed criminal petition number of their organization. In the meantime, the petitioners have approached this court seeking to quash the criminal proceedings initiated against them. However, learned counsel for respondent. Learned counsel for the petitioner has not addressed his argument, as his argument is taken as nil. Peruse the materials, point for consideration. My answer to the above point in the negative for the following reasons. The police inspector attacked to Karnataka Lokaयुcta police filed the source report collecting the informations about the assets and liabilities, income and expenditure of accused number 1 and 2, and filed the source report holding that the accused have amassed disproportionate wealth, which is about 166% to the known source of income, and thereby committed the offense. After investigation, charge sheet came to be filed to the effect that the disproportionate assets amassed by the accused was 62.60%, and they have committed the offense as stated above. ಏನು ಸರ್ ದಯವಿಟ್ಟು ಕೂತ್ಕೊಳ್ಳಿ ಕೂತ್ಕೊಳ್ಳಿ. As stated above. Next slide. My attention was drawn by the learned counsel for the respondent that initially the learned special judge had framed charge for the offences committed by accused number 1 and 2. At that point of time, petitioners have approached this court by filing similar petition in the criminal petition number 6129 of 2016, seeking quashing of framing of the charge and also the entire proceedings initiated against them. The coordinate bench of this court, with an order date of 27/11/2017, considered the contention taken by the petitioners and directed the trial court, directed the petitioners to file necessary application seeking their discharge and also directed the trial court to consider such application by providing opportunity to both parties and to dispose of the application within 1 month from the date of application. Next part. It is stated that after disposal of criminal petition number 6129 of 2016, the petitioners have moved an application before the special court under section 239 of CRPC, seeking their discharge. The trial court, with an order dated 6/1/2018, passed a detailed order dismissing the application filed by the petitioners under section 239 of CRPC and refusing to discharge them, holding that there are sufficient grounds to proceed against the petitioners. Next part. It is pertinent to note that the trial court has rejected the discharge application filed by the petitioners as per order dated 6/1/2018. This petition was deemed to be filed by the petitioners on 2/2/2018. But the petitioners are not seeking to quash the petitioners are not challenging the order dated 6/2/2018 passed by the trial court, refusing to discharge the accused. But on the other hand, they are again seeking to quash the criminal proceedings initiated against them. Next part. On going through the order dated 6/1/2018, the trial court has taken into consideration the voluminous documents produced by the investigating officer while filing the charge sheet, and for forming the opinion that the accused have amassed wealth disproportionate to their own source of income, which is about 62.60% higher than the known source of income. The trial court came to the conclusion that the materials on record prima facie discloses commission of offence and there are sufficient grounds to proceed against the accused by framing the charge. Next slide. The investigating officer has cited as many as 73 witnesses to speak in support of the case made out by the prosecution. It is stated that accused number 1 is the elected representative, being the corporator of ward number 141, Azad Nagar, BBMP Bengaluru, elected during 2010. The check period is from 5/4/2010 to 9/11/2012. The FIR was again to be registered on 8/11/2012 and the raid was held on 9/11/2012. As per the final report, the worth of the assets amassed by the petitioners from 28 during the check period is rupees 5,11,75,506. And the expenses during this period was rupees 3,89,52,690. Whereas the income from the known source of income, was only rupees 5,54,28,504. And the disproportionate asset is rupees 3,46,99,693. In support of the same, the investigating officer has collected sufficient materials. Next, as rightly contended by the learned counsel for the respondent, as per section 13(1)(e), the burden is on the accused to satisfactorily explain account for the assets in his hands. When there are sufficient materials to constitute the offense in question, the accused are liable to face the trial and take necessary defense before the trial court. Since there are strong prima facie materials against the petitioner to constitute the offense, I am of the opinion that the petitioners are not entitled any relief in the petition. It is noticed that the criminal petition was filed in the year 2018, and since for more than 6 years, the matter is pending before the trial. Therefore, the trial court is directed to expedite the trial in the matter without further loss of time. Accordingly, I answer the above point in the negative and proceed to pass the following. Petition is dismissed. Trial court is directed on it. Yes, dismissed.
Great.
Serial number 19, B. Ramesh.
Not a regular corporator will not issue. Corporator only for 2 years, 7 months only short.
ಅದೇ ಚೆಕ್ ಪೀರಿಯಡ್ ಸರ್.
Yes, sir, 2 years, 7 months.
ನೀವು 2 years ನಲ್ಲೇ ಅಷ್ಟು ಮಾಡಿದಿರಿ, 62% ಜಾಸ್ತಿ ಮಾಡ್ತಾರೆ.
Property, that's what they say.
ಡಿಫೆನ್ಸ್
Property.
ಡಿಫೆನ್ಸ್ ತಗೊಳ್ಳಿ. 2 ವರ್ಷಕ್ಕೆ ನೀವು ಅಷ್ಟು ಮಾಡಿದಿರಿ ಅಂದ್ರೆ ಇನ್ನು ಕಂಟಿನ್ಯೂಸ್ಲಿ ಮಾಡಿದ್ರೆ.
Other source of income that they are not.
Sir, it is a matter for trial. You can take the defense before the trial. Not a ground for quashings. Okay. Next.
Till number 19, B. Ramesh, A. V. Amarnathan.
This case, today order sheet was over.
If not, by 6:10, they do the same thing, pass over till evening, I'll be waiting.
That
You're
is the
not-
tactic that is being played on.
That, in fact, I need an adjournment, Your Honor. Yeah, I need an adjournment because my junior met with an accident, was handling this case. I had to appear. I need some time, 1 week time. Second response.
ತಗೊಳ್ಳಿ. ನಿಮ್ ಗಮನ ಈ ಕಡೆ ಇರ್ಬೇಕು. The counsel for the petitioner seeks a crossover. The counsel for respondent number 2 is for a short time on the ground that his colleague met with an accident and he has to rush to the hospital. Hence, list off. Next. Yes, next.
Serial number 20, Aditya Narayan. Yes, sir.
Yes.
I appear on behalf of Mr. Aditya Narayan, Your Lordship. Request an adjournment as the SLP is pending before the Supreme Court, Your Lordship. That has a significant bearing in this present proceedings, Your Lordship. The SLP was preferred by the respondents, Your Lordship. That matter was supposed to be listed in February 2024. Thereafter, it was not listed. It has a very significant bearing in the present proceedings, Your Lordship.
Let me hear both of you on merits and consider, according to you, the matter pending before the Honorable Apex Court is having bearing on the present petition, whereas it is disputed by the other side. Every
Okay.
time we cannot go on making the same submission. I will
No,
hear
Your
you on merits and decide.
Sure, Your Lordship. My senior will address the argument. My senior will address the argument.
If I feel that the matter pending before the Apex Court is having any bearing, I will adjourn them. Please
Noted,
go
Your
on with the matter.
Your Lordship, I request an adjournment as my senior is in Delhi. He will address the arguments. Kindly give me 2 weeks' time, Your Lordship. He'll address the arguments.
When will you argue?
2 weeks' time may be given, Your Lordship.
Because
My senior.
Even on the last date of hearing, there was a direction to address the arguments on merits.
Your Lordship, today is at Delhi, Your
Why
Lordship.
you are seeking time.
Today is in Delhi as on another
Every
matter.
day you will be somewhere, sir. What is to be done?
2 weeks' time, Your Lordship. We'll address the arguments, Your Lordship.
Learned counsel for the petitioner.
Only one submission.
Hmm.
It's a matter involved, my lord, is 215 crores. They are dragging the issue. And
This
it's as good as interim order is already passed in this Honorable High Court, a detailed interim order is passed.
I will record all those things, sir. Counsel for the petitioner again submits that the matter pending before the Honorable Apex Court is having bearing on the present petition and therefore takes the time. For control and counsel for respondent number 2 again opposes the move and submits that deliberately the matter is being dragged on as the petitioner is enjoying the benefit of the interim order. The order is dated 10/1/2025 reads as under. In spite of the direction, the counsel for the petitioner is seeking adjournment. I do not find any reason to adjourn the matter. I find considerable force in the contention taken by respondent number 2. However, to afford opportunity, since the learned counsel for the petitioner undertakes to address his arguments on merits on the next date of hearing without fail, I am of the opinion that one more chance may be given, one more opportunity could be given for the petitioner to address his arguments. It is made clear that if the petitioner fails to address his argument on the next date of hearing, his argument will be taken as nil and the matter will be disposed of on merits. List finally as a last chance. Yavak.
2 weeks' time may be given, Your Lordship.
Right. Okay. Sir, no further adjournment on any ground.
I understand, Your Lordship. The order of this division bench has been challenged before the Supreme Court by the respondents, Your Lordship.
Let me see. Please go on with the matter on merits.
Yes, Your Lordship. 2 weeks' time may be given.
And the synopsis also. I find the synopsis.
Counsel for responding number 2 filed the synopsis.
Maybe I may be furnished a copy, Your Lordship.
Your colleague is here. Or hoda?
Yes. Yes, Your
Endorsement ಇದೆಯಾ ಅವ್ರದ್ದು?
ಇಲ್ಲ ಎಂಡಸ್ಮೆಂಟ್ ಈಗ ಓಪನ್ ಕೋರ್ಟಲ್
Open court ನಲ್ಲಿ ಕೊಟ್ರೆ ನಾಳೆ if he disputes, I do not know. That may be the ground for adjournment then.
No, Your Lordship.
Serial number 21, Vinay Kumaran, Akash.
Much obliged.
Vinay
Put it.
Kumar.
Yeah, for the respondent.
Yes.
My-
What is this?
My lord, it is case of 498A, husband has challenged this petition.
One minute. Tawni. Petitioner is absent, no representation. Order sheet dated 15/1/2025, released as an. In spite of that, there is no representation. Hence, the document on behalf of the petitioner is taken as nil. Yes. Trustee one. Yes, put it. Petitioner is
Petitioner is accused number 1, my lord, husband, my lord.
in all how many accused?
My lord.
In all how many accused?
My lord, after in the charge sheet, there are 5 accused has been made, my lord. In the FIR, only 2 accused has been made, my lord.
Who are they? Accused number 1 is the husband.
Accused number 1 is the husband, my lord.
Mm.
Accused number 2 is the mother-in-law, my lord.
3.
3 is the sister, my lord. Sister.
Hmm.
And 4 is Natraz is the father, my lord.
Hmm.
5 is Vijay Manjunath, my lord.
Hmm?
Vijay Manjunath, my lord.
In relationship in.
Relationship is relative, my lord. Relative ಅಂತ ಇದು ಮಾಡಿ. My lord, in this case, charge sheet is filed, my lord. And my lord,
What
they
are
have
the offense alleged?
offense 498A of APC, my lord.
Only 498.
498, and also forcing her to sign the petition for divorce, which is filed in Australia in the court of
Charge sheet ಎಲ್ಲಿದೆ? ಇಲ್ಲಿ.
charge sheet is, my lords may kindly see page number 29, my lord. 29, it starts, my lord.
Yes, column number 7, please read.
Yes, my lord. May I read, my lord?
Yes.
ಸಾಕ್ಷಿ 1ರ ಮಗಳರಾದ ಸಾಕ್ಷಿ 4ರ ಆರೋಪಿ ಅವರನ್ನು ಪ್ರೀತಿಸಿದ್ದು ಪರಸ್ಪರ ಒಪ್ಪಿ ದಿನಾಂಕ ಸೊನ್ಸಂಡ್ 10 ಲಕ್ಷ ರೂಪಾಯಿಗಳನ್ನು ಖರ್ಚು ಮಾಡಿ ಚೈನು ಮತ್ತು ಉಂಗುರಗಳನ್ನು ಆರೋಪಿ ಮತ್ತು 1 ಮತ್ತು ಸಾಕ್ಷಿಯರವರೆಗೆ ಮದುವೆ ಮಾಡಿ ಕೊಟ್ಟಿರ್ತಾರೆ. ನಂತರ ಆರೋಪಿ 1 ದುಬೈಗೆ ಹೋಗಲು 1 ಲಕ್ಷ ರೂಪಾಯಿಗಳನ್ನು ಟಿಕೆಟ್ಗಾಗಿ ಪಡೆದು ನಂತರ ದುಬೈನಲ್ಲಿ ಸಾಕ್ಷಿ 4ರವರ ಕೆಲಸ ಮಾಡಿದ ಪ್ರತಿ ತಿಂಗಳ ಸಂಬಳವನ್ನು ಆರೋಪಿ 2ರವರೆಗೆ ಕಳಿಸಿ ಕೆಂಪಾಪುರದಲ್ಲಿ ಫ್ಲಾಟ್ ಅನ್ನು ಖರೀದಿ ಮಾಡುತ್ತಾರೆ. ನಂತರ ಸಾಕ್ಷಿ 4 ಮತ್ತು ಆರೋಪಿ 1 ಮತ್ತು 3 ವರ್ಷಗಳ ಕಾಲ ದುಬೈನಲ್ಲಿ ಇದ್ದು ನಂತರ ಅಲ್ಲಿಂದ ಆಸ್ಟ್ರೇಲಿಯಾಕ್ಕೆ ಹೋಗಿರ್ತಾರೆ. ಆದರೆ ಸುಮಾರು 5 ವರ್ಷ ಕಳೆದರೂ ಅವರು ಸಹ ಸಂತಾನ ಭಾಗ್ಯವಿಲ್ಲದ ಕಾರಣ ಬೆಂಗಳೂರಿಗೆ ವಾಪಸ್ ಕರೆದುಕೊಂಡು ಬಂದು ಬೆಂಗಳೂರಿನ ಬಸವನಗುಡಿಯ ಗುಣಶೀಲ ಆಸ್ಪತ್ರೆಯಲ್ಲಿ 3 ರಿಂದ 4 ಲಕ್ಷ ಖರ್ಚು ಮಾಡಿಸಿಕೊಂಡು ಚಿಕಿತ್ಸೆ ಫಲಕಾರಿಯಾದ ಕಾರಣ 2ನೇ ಬಾರಿ ಚಿಕಿತ್ಸೆ ಕೊಡಿಸಬೇಕೆಂದು ಮಾನಸಿಕವಾಗಿ ಮತ್ತು ದೈಹಿಕವಾಗಿ ಹಿಂಸೆ ನೀಡಿರುತ್ತಾನೆ. ಆರೋಪಿ 1ರವರ ಮನೆಗೆ
W4
CW
ಸಾಕ್ಷಿ 4ರವರು ಕೆಲಸ ಮಾಡಿದ ಪ್ರತಿ ತಿಂಗಳ ಸಂಬಳ. Who is CW4?
ಎಸ್ ಮ್ಯಾಮ್. ಮಾನಸ ದೇವಿ ಆರೋಪಿ ವಿನಯ್ ರವರ ವಿವಾಹದ ಲಗ್ನ ಪತ್ರಿಕೆ ಅಸಲು.
Is the wife.
my lord.
ಈ ಫ್ಯಾಕ್ಟ್ಸ್ ಎಲ್ಲ ನೋಡ್ಕೊಳ್ಳೋದಿಲ್ವ?
ನೋಡ್ಕೊಂಡ್ ಬಂದಿದ್ದೀನಿ my lord. ನೋಡ್ಕೊಂಡ್ ಬಂದಿದ್ದೀನಿ my lord. Only my lords may kindly see my lord. Page number 50 my lord. It is the application for divorce. The father, the accused number 4, he gets that the application for divorce and asks the complainant daughter to sign the same my lord. And she refuses my lord, and then she files the complaint. The reason for the divorce is she has not conceived, my lord, and my lord, they have given and also reason the complaint says, my lord, that the reason for not conceiving is means they have given mental harassment to the complainant daughter, my lord. That is the case, my lord.
This is petitioner is only accused number 1.
My lord.
Other accused have not approached.
Not approached in this petition. Only accused husband has been.
So what? Petitioner being accused number 1. In the CC number 9123 of 2018, bracket nalli arising out of time number 24 of 2018 of Mahalakshmi Layout Police Station, registered for the offence punishable under section 498A, read with section 34 of IPC and under section 4 of DP Act, pending on the file of the learned 7th Additional Chief Metropolitan Magistrate Bengaluru, is seeking to quash the criminal proceedings initiated against him. The facts of the case are that respondent number 2 being the father, respondent number 2 is the father of the wife.
Yes.
Father of the wife of the petitioner.
Please, ma'am.
File the first information against accused numbers 1 and 2, alleging commission of offence punishable under section 498A of IPC. The investigation was undertaken. Charge sheet came to be filed against accused numbers 1 to 5, alleging commission of offence punishable under section 498A, read with section 34 of IPC, and under section 4 of Dowry Prohibition Act. Next part, it is the contention of the prosecution. The daughter of the CW4 is the daughter of the informant, and she was in love with accused number 1, who is the petitioner herein. Their marriage was arranged by the informant on 19/11/2009 by spending rupees 10 lakhs. He stated that at the time of marriage, accused number 1 has received a gold chain and a gold ring. Thereafter, he went to Dubai, for which for arranging the ticket. The informant was made to pay rupees 1 lakh. Even though CW4 was staying in India, she was made to pay her entire salary to accused number 2 by utilizing the same. An apartment of Kempapura was purchased. Accused number 1 went to Australia. CW4 was getting treatment for conceiving in Bengaluru, for which the informant has spent rupees 3 to 4 lakhs. It is alleged that the accused were physically and mentally ill-treating CW4 and they were insisting for additional dowry of rupees 15 lakhs. It is also alleged that accused number 1 was insisting CW4 to give him the divorce, and he tried to get the signatures of the signature of CW4 forcibly. Accused number 4 and 5 have joined hands with accused number 1 in forcing CW4 to sign and to give consent and to sign for divorce. Thereby, the accused have committed the offense against CW4. The petitioner, being accused number 1, is before this court seeking to quash the criminal proceedings. The petitioner remained absent and has not addressed his argument in spite of giving sufficient opportunity. Heard Leonard HCGP for respondent number 1. Peruse the materials, point for consideration, and answer to the above point in the negative for the following reasons. The informant, being a father of CW4, filed the first information making specific allegations against the present petitioner. After investigation, a detailed charge sheet came to be filed. The prosecution has cited as many as 13 witnesses in support of its contention regarding commission of the offense by the petitioner. The petitioner is said to be the husband of CW4, against whom the offense is said to have been committed. Statement of CW4 is recorded by the investigating officer. The further statement of the informant is also recorded. All these materials prima facie discloses commission of offense. Under such circumstances, I do not find any reason to quash the criminal proceedings. Accordingly, I answer the above point in the negative and
for admission, serial number 22, Bharat Kumar V, Ramu S. Arising out of PCRA.
The matter where the petitioner had owned a property and it was transferred in the name of the respondents. Subsequently, my lords, at that time, it seems that there were 5 dwelling houses which were rented. And subsequently, there was some dispute and the petitioner had filed a suit for cancellation of the deed, which has ended in compromise dated 14/12/2019, and by which it seems that the petitioner has paid off those leased out people and have vacated the premises, and the vacant possession is handed over to the respondents. But the petitioner is not reachable now. And this being the case, one of the grounds for Millard's challenge is that they have not followed the Priyanka Srivastava case and affidavit is not filed. So Millard's may consider this, that it may be remanded back on that basis. It is a curable defect. It may be remanded on that basis. And if the respondents were to feel that this has to be proceeded with, they can file an affidavit and proceed.
yes,
Please, your lordship.
affidavit.
Affidavit is not filed.
Affidavit not filed. Only on that ground I will direct. So, what is the offense?
Millard's, it is 405,
415, 418.
Petitioner is accused number, only accused?
Only sole accused.
The petitioner being the sole accused. So, CC is not registered?
Please, no. It is for 156.3, it was ordered for investigation.
The matter is stayed.
Petitioner being sole accused in PCR number 14695 of 2018, pending on the file of the learned Chief Metropolitan Magistrate Bengaluru for the offence under section 405, 415, 418, 423, 441, 350, read with section 34 of IPC, is seeking to quash the criminal proceedings initiated against him. The fact is of that respondent number 2 as complainant. Who is the joint complainant? Who is the complainant?
Both are defendant respondents.
Respondent number 2 and 3 as complainants filed the private complaint PCR 14695 of 2018 against the petitioner alleging commission of the offence as stated above. What is allegation? Where is the FIR? FIR is there.
The allegation, my lord, PCR, find it at page number 24.
No, 21 only, gist of the complaint.
Page 21.
He stated that the accused has sold property number 11, measuring a site measuring 30 by 40, situated at Hongasandra village, with the RCC building in favor of the complainant, in favor of respondent number 2, under the sale deed dated 5/6/2017. Five houses situated therein were leased by the accused. And he promised to repay the lease amount to the tenants, lease amount of rupees 9,80,000 to the tenants, and promised to get them vacated. In spite of that, accused has not vacated the tenants. The checks issued by the accused gets bounced, and separate complaint was registered against him. Therefore, it is the contention of the complainant that the accused has committed criminal breach of trust and caused the loss. The trial court referred the matter for investigation under section 156(3) of CRPC. The petitioner being the accused is before this court seeking to quash the criminal proceedings. Third solution. For the materials, point for consideration, my answer to the other point in the partly in the affirmative for the following reasons. The only ground urged by the learned counsel for the petitioner is that the complainant has not complied with the directions issued by the Honorable Apex Court in Priyanka Srivatsa. No affidavit was filed by the complainant for having complied the requirement of section 150, 153 4
154(3).
43 of CRPC, and therefore, learned counsel for the petitioner prays for directing the trial court, directing the complainant respondent number 2 and 3 to comply with the requirements of the directions issued by the Apex Court in Priyanka Srivatsa. Then the XCP for respondent number 1 has no objection for the same. Then counsel for respondent number 2 and 3 remained absent and mail variety remained absent and no representation. His argument is taken as nil. ಇಲ್ಲಿ ಕೆಳಗಡೆಗೆ even though learned counsel for even though respondent number 2 and 3 were represented by their counsel, he has not addressed his argument. Next part, on perusal of the materials on record, it is found that even though the private complaint is filed by respondent number 2 and 3, making specific allegations against the petitioner, no affidavit appears to have been filed by them before the trial court in compliance of section 154(3) of CRPC. Thereby, the directions issued by the Honorable Apex Court in Priyanka's favor to file an affidavit to speak about the compliance of the requirement of law for having filed the complaint with the police or for having sent the copy of the complaint to the higher officers through post is not being complied with. Under such circumstances, the said defect is a curable defect, and under such circumstances, the same cannot be a ground to quash the criminal proceedings. The respondent number 2 and 3 may be directed to cure the defect by filing necessary affidavit in terms of the directions issued in Priyanka's favor. And on consideration of the same, the trial court can proceed pass appropriate orders. In view of the above, I answer the above point partly in the affirmative and proceed to pass the following. Petition is allowed in the prayer of the petitioner to quash the criminal proceedings is rejected. Respondent number 2 and 3 are directed to file necessary affidavit in compliance of the directions issued by the Apex Court in Priyanka's favor. And on filing this affidavit, the trial court is directed to proceed with the matter in accordance with law. Yes. Ali, in view of disposal of the petition, IA 1 of 2020, all stands disposed of. Yes. Next, ಮತ್ತೆ ಅದು ಪಾಸ್ ಓವರ್ ಆಗಿದೆ. 17 ಇದಕ್ಕೆ ಪಾಸ್ ಓವರ್ ಆಗಿದೆ ಅವರೇ ಕೇಳಿ. Yes.
Legal highlights. One is nothing extinguished. Like I forgot to. Number 5.
ಏನಾಗಿದೆ ಅದ್ರಲ್ಲಿ ಆರ್ಡರ್ ಶೀಟ್ ಏನಾಗಿದೆ? ಐ ಡೋಂಟ್ ನೋ. You are enjoying the benefit, but you are not willing to comply with the.
Complete several things, not one side, because notice has to go to the US. I've taken several steps.
ಅದಕ್ಕೆ ಸ್ಪೆಸಿಫಿಕ್ ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್ ಕೊಡ್ಬೇಕು, ಸ್ಟಾಂಪ್ಸ್ ಕೊಡ್ಬೇಕು.
ಅಲ್ಲ, ಅದು that's why we said ನಾಳೆ
ಅದು ಏನು ಆರ್ಡರ್ ಶೀಟ್ ಏನು ಬರ್ದಿದ್ದೀನಿ ನೆನಪಿಲ್ಲ. It is noticed that the petitioner is enjoying the benefit of the interim order. However, he is not diligent in paying the PF with the required stamp. The undertaking given by the learned counsel for the petitioner to do the needful is placed on record. Subject to the condition, the interim order is extended. List of finally exhaustions. Yes. If PF is paid with the required stamp, acknowledgement, etc., issue notice. Yes.
Court officer, madam. Court officer, madam. Court officer, madam.
court officer, sir.
Court officer, madam.
ಅದು ಏನಾಗಿದೆ ಅಂತ ಗೊತ್ತಿಲ್ಲ. ಸರ್ ಇದು ಧಾರವಾಡ ಕಲಬುರ್ಗಿ ಬೆಂಚ್ ಅರುಣಾ ಚವಾನ್ ಇದ್ದಾರೆ.
ನಾನು ಜಮಾದಾರ್ ಕಾಪುತ್ತೀನಿ SCGP.
ಸರ್ ಇವ್ರು ಬೇಕಿತ್ತು ಅರುಣಾ ಚವಾನ್ ಅವರು.
ಇದ್ದೀನಿ ಮೇಡಮ್.
ಇದ್ದೀರಾ ಮೇಡಮ್? ಓಕೆ.
ಕೊಡಬಿ ಸರ್.
ಸರ್ ಹೇಳಿ.
ನನ್ನ ಹೆಸರು ಜಮಾದಾರ್ ಶಾಪುತ್ತೀನಿ ಅಂತ.
ಹಾ ಸರ್ ಬರ್ಕೊಂಡಿದ್ದೀವಿ.
ಓಕೆ ಸರಿ ಸರಿ.
Good afternoon, sir.
डिस्पोज हुआ क्या?
जी सर.
डिस्पोज हुआ वहाँ पे जजमेंट हो गया?
हाँ हो गया सर.
ನಿನ್ನೆ ಮ್ಯಾಟ್ರಲ್ಲಿ ಲಿಸ್ಟ್ ನಂಬರ್ 2 ಸೀರಿಯಲ್ ನಂಬರ್ 20 ಮೇಡಮ್.
ಎಕ್ಸ್ಟೆನ್ಷನ್ ಕೇಳಿದ್ವಿ ಬಟ್ ಅಪ್ಲೋಡ್ ಆಗಿಲ್ಲ ವೆಬ್ಸೈಟ್ ಅಲ್ಲಿ. ಮೇಡಮ್ ಸ್ವಲ್ಪ ಅಪ್ಡೇಟ್ ಮಾಡಕ್ಕಾಗತ್ತಾ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಮೇಡಮ್?
ಏನ್ ಹೇಳಿ?
ನಿನ್ನೆ ಲಿಸ್ಟ್ ನಂಬರ್ 2 ಸೀರಿಯಲ್ ನಂಬರ್ 20 ಅಲ್ಲಿ ಫಸ್ಟ್ ರೌಂಡ್ ಪಾಸ್ ಓವರ್ ಆಗಿತ್ತು, ಮತ್ತೆ 2:30 ಲಿಸ್ಟ್ ಆಗಿತ್ತು. ಅದು ಇಂಟ್ರಿ ಮೋಡ್ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಕೇಳಿದ್ವಿ, ಎಕ್ಸ್ಟೆನ್ಷನ್ ಆಗಿದೆಯಲ್ವಾ ಅಂತ, ಯಾಕಂದ್ರೆ ಅಪ್ಲೋಡು ಆಗಿಲ್ಲ, ಅದಕ್ಕೋಸ್ಕರ ಕೇಳ್ಬೇಕಾಗಿತ್ತು.
ಯಾವ ಲಿಸ್ಟ್ ಮೇಡಮ್?
ನಿನ್ನೆ ಮೇಡಮ್, ನಿನ್ನೆ ಲಿಸ್ಟ್ ನಂಬರ್ 2 ಸೀರಿಯಲ್ ನಂಬರ್ 20 ಮೇಡಮ್.
ಗೊತ್ತಿಲ್ಲ ಅಲ್ಲ ಮೇಡಮ್, ಫೈಲ್ ಅಲ್ಲೇ ನೋಡ್ಬೇಕು.
ಅಲ್ಲ ಕೇಳಿದ್ವಿ, ಅದು ಎಕ್ಸ್ಟೆನ್ಷನ್ ಇಂಟರ್ನೆಟ್ ಅಲ್ಲಿ ವೆಬ್ಸೈಟ್ ಅಲ್ಲಿ ಅಪ್ಲೋಡ್ ತೋರಿಸ್ತಾ ಇಲ್ಲ, ಅದಕ್ಕೋಸ್ಕರ ಕೇಳ್ತಾ ಇದ್ದೆ ಮೇಡಮ್. ಅಟ್ಲೀಸ್ಟ್ ಸ್ಟೆನೋ ಯಾರಂತ ಹೇಳಿದ್ರೆ ನಮ್ ಕಲೀಗ್ ಕಳ್ಸಿಕೊಡ್ತೀನಿ, ಅವ್ರು ಹೋಗಿ ಅಲ್ಲಿ ಕೇಳ್ತಾರೆ, ವಿಚಾರಣೆ ಮಾಡ್ತಾರೆ. ಯಾಕಂದ್ರೆ ನನಗೆ ಫಿಸಿಕಲ್ ಆಗಿ ಬರಕ್ಕಾಗಿಲ್ಲ, ದೇರ್ ಇಸ್ ಸಮ್ ಪರ್ಸನಲ್ ಇಂಜುರಿ ಟು ಮೀ, ದಟ್ಸ್ ರೀಸನ್.
ಮೇಡಮ್ ಆಫೀಸಿಗೆ ಬಂದು ವೆರಿಫೈ ಮಾಡಿ ಮ್ಯಾಮ್.
ಓಕೆ ಆಯ್ತು ಮೇಡಮ್.
ಬೋರ್ಡ್ ಮೂವ್ಮೆಂಟ್ ಇಲ್ದಿರ ಆಗೋಗಿದೆಯಲ್ಲ ಮಕ್ಕಳಿಗೆ.
ಇಷ್ಟ ಬರ್ತಾ ಇಲ್ವಾ? ಮೊದಲೇ ಹೇಳತ್ತಲ್ಲ.
ಹೇಳಬೇಕು ಕೇಳಿಲ್ಲ.
21 ಅಲ್ಲಿ grant ಅಲ್ಲಿ ಇದ್ದಿಲ್ಲ. 2021 ಅಲ್ಲಿ recruitment ಅಲ್ಲಿ ತಾನೇ ಇದ್ದೀವಿ. 2021 group D. ಶುಭ.
Vice President to deal with that. ಅದೇ election continue, ladies.
ಸರಿ.
Recruitment ಅಲ್ಲಿ ladies.
ಅಲ್ಲಿದ್ರಲ್ಲ ಅದೇ ಮಾಡ್ತಾ ಇದ್ದೀವಿ ನಾವು ಅನ್ಕೊಂಡೆ. Vice President ಗಂಡಸಪ್ಪ ಅವ್ರಿಗೆ PG ಮುಂದೆ ಹೇಳ್ಕೊಂಡು
Vice President. Entire association vice president ಒಬ್ಬರ ಮತ್ತೆ ಯಾರೋ ಕ್ರಿಯೇಟ್ ಮಾಡಿದ್ದಾರೆ. ಫಸ್ಟ್ ಟೈಮ್
ಏನೇನೋ ಕತೆ ಆಗೋಗಿದೆ.
ಅವ್ರು ಚೆನ್ನಾಗಿದ್ದಾರೆ ಪ್ರೆಸಿಡೆಂಟು.
ಪಾಪ ಆಫೀಸಿಗೆ ಬಂದ್ಬಿಟ್ರೆ ನಿಮಗೆ ಸಿಕ್ಕಿರ್ತಿ ಎಲ್ಲ ಇರ್ತಾರಲ್ಲ, ಸೊ ಸೇಫಾಗಿ ಆಟೋನ ಬುಕ್ ಮಾಡಿದ್ದಾರೆ. ಆಟೋ ಅಂತ ಬಂದಾಗ ಹೇಳ್ಕೊಂಡಿದ್ದಾರೆ. ಆಟೋದಲ್ಲಿ ಹೋಗಿದ್ದಾನೆ, ಅಷ್ಟರಲ್ಲಿ ಪಾಸ್ ಆಗಿದೆ. ಒಂದು ಸ್ಲಿಪ್ಪರು ಹುಡುಗನ ಮೊಬೈಲು PG ಮುಂದೆ ಬಿದ್ದಾಗಿದೆ. ಫೇಸ್ ಮಾಡೋಕ್ಕಾಗಿಲ್ಲ, ಹೊರಟಿದ್ದಾರೆ. ಪೊಲೀಸವ್ರಿಗೆ ಇದು ಮಾಡೋಷ್ಟರಲ್ಲಿ ಇದು ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾನೆ. ಜೊತೆ matter pertaining to Kalburgi bench, serial number 1, Aruna Chavan. Madam, Aruna madam.
Your Lordship, I withdraw this petition, my lord.
You are withdrawing it?
Yes, my lord.
Learned counsel for the petitioner seeks permission to withdraw the petition. Submission is placed on record. Petition is dismissed as withdrawn. Dismissed as withdrawn.
Grateful.
List 2. Non-compliant for first time, serial number 1, Prasanna Kumar B.
Counsel for the petitioner is absent, representation placed on.
Serial number 2, yes, Balakrishnan.
Same.
Order first time address, serial number 3, Lakshmikant K.
Issue notice. SCGP, learned SCGP takes notice for responding.
Serial number 4, Manoranjini. Madam Manoranjini.
I appear for the respondent in this case. On the last occasion, this honorable court directed me to
Yes,
verify the stays, my lord. I have verified it is HBC, my lord, hearing before charge, and the matter is listed on 4th February, my lord.
For?
Hearing before charge, my lord.
Yes, to this hearing.
Ashte agite.
At least charge could be framed, Allah.
Yes, ma'am. Since he is the resident of Bengali.
Learned counsel for the petitioner is absent, no representation. Even though she is appointed by the High Court Legal Services Committee. Same is to be reported to the committee. Our office is directed to report the same to the committee.
A3, A6, A7 are absconding, my lord. Hangagi
Even though the petitioner has filed the petition seeking the relaxation of the condition, it is not made clear as to which is the condition she wanted to be relaxed. This petition is dismissed.
please, madam.
Next.
Serial number 5, Arjun. Serial number 6, B. Latif.
Question number 5. Counsel for the petitioner is absent, no representation is done. Next.
Serial number 7, Ravi HK.
Representation. ಯಾಕೆ ಯಾರು ಇಲ್ಲ?
Passed over matter. List 1, serial number 2, J. Somsekhar, P. Mahesh, P. Siddhaya.
I beg for the respondent to my lordship. She says, my lordship, I have not agreed for anything. They have not paid such an amount. That's what she tells, my lordship.
Where amount? Auto sheet ಕೊಡಿ, profile ಕೊಡಿ. Do you have any document to show that you have paid the amount as undertaken?
No, I have a document. Bank statement is there, it is clear to our account.
That is the document evidencing payment. It is transferred through bank,
Bank, check only.
check. She has encashed the check.
Okay, there,
Produce the bank statement.
please.
What is the amount that is undertaken to be paid?
95 lakh rupees. Rashippa, kindly
One,
take the compromise petition in page 5. Para number 15.
Hmm.
The plaintiff consent for the degree eviction of the scheduled property, scheduled 5th and 6th properties on expiry 31/3/2033. The defendant, first defendant has no objection, grant such a type. Why I am reading? Now she is in possession. She alienated in favor of me, even though age factor, a request, given consent up to 33. She is in possession, even this juncture, she is making a false.
when you purchased it from her,
From her, have purchased property. At Sun, 2015.
this compromise is with the,
Her only. She only filed the suit for the declaration. Order sheet also, all advocates are there.
tell me the facts. I'll decide on merits.
Lordship, on merit, another date may kind of.
No, sir, sorry. No.
Serial number.
ಹಾ. ಆಯ್ತು, ಗೊತ್ತಾಯ್ತಮ್ಮ, ನಾನು ನೀವು ಹೇಳೋದು ನನಗೆ ಗೊತ್ತಾಗಿದೆ. ಆಯ್ತು ಆಯ್ತು ಆಯ್ತು, ಆನ್ ಮೆರಿಟ್ಸೇ ಮಾಡ್ತಾ ಇದ್ದೀನಿ ನಾನು, ಬೇರೆ ಏನು ಮಾಡ್ತಾ ಇಲ್ಲ. ಎಸ್, ವಾಟ್ ಆರ್ ದ ಫ್ಯಾಕ್ಟ್ಸ್? ಹೂ ಇಸ್ ದ ಪಿಟಿಷನರ್?
Now the page, next B.
Sir, who is the petitioner?
A1 is the petitioner, Ramakrishna Reddy.
In all, how many accused are there?
The 4 accused.
What are the
4
offense?
complaints she filed. Three in Happaguri and 1 in JP Nagar. Kindly take the in page 51, that is the complaint. $794 case.
Accused number 1 is the petitioner in which petition?
794.
790?
794 2000.
Accused number 1. Who is the petitioner in 799?
Ramakrishna Reddy. 794, Ramakrishna Reddy is the petitioner, the accused number 1. 799, Ramkrishna Reddy is the accused in number 1 and petition.
Why petitioner, accused number 1 has filed 2 petitions?
There are 3 complaints filed, 4, totally 4. One is in JP Nagar, 3 in Habagudi police station.
So in 799 crime number? You are not ready with the facts? Counsel for respondent number 2. Submits that respondent number 2 who is present with the court. And counsel for respondent number 2. Submit that as per the instructions from the respondent number 2, there was no compromise as suggested, and she has not received any amount from the petitioners. For control and counsel for the petitioners submits that the amount agreed under the compromise is paid to respondent number 2 through check, and the check in question was encashed by her. We undertake to produce the statement of the bank to evidence the same. Both the loan counsel pray for time to address their arguments on merits. List. When will you produce bank statement? You produce and get ready to address the arguments. Undertake. Both the loan counsel undertake to address their arguments on merits on the next date of hearing without fail. Submission is placed on record. Subject to the above condition, interim order is extended. List finally as the last chance.
Serial number 7, Jayanta Pujari.
Date ಕೊಡ್ತಾರೆ ಸ್ವಲ್ಪ ನೋಡ್ಕೊಳ್ಳಿ. ಬೇರೆ ಮೇಂಟೈನ್ Third limit comes the petitioner and the office objection regarding maintainability of the petition. It is noticed that the crime number in the present petition and in the petition referred to by the office are two different numbers. Hence, office objection regarding maintainability is overruled. Next one, admission. Issue notice. SCGP takes notice for respondent. SCGP for respondent.
The joint memo was filed. Other three connected case last both the parties are present. Now affidavit is ready, but both the parties are in USA. They will permitted to be present UC Melot.
ಆಯ್ತು ಮಾಡಿ ಯಾವಾಗ
2 weeks time.
Counsel for the petitioner submits that the parties have amicably settled their dispute amicably. Since the parties are in they are in USA, he will keep the parties present through video conference. He is permitted to do so. This time. Necessary application will have to be filed. Yes.
Serial number 17, Kamaluddin, Syed Kamaruddin, Ashok B. Patil.
Yes. Yes, yes.
In nutshell, coming substance, then I take my notes to all the documents.
Mm.
The complaint, my lord, is stating that the petitioners, that is the accused number 3 in this case, the petitioner in the other case has cheated the complainant
Yes.
by not paying certain amounts which are promised to be paid to him under the joint development agreement.
Mm.
And then that liability was passed on to the purchaser. I was the purchaser by way of an exchange deed.
Mm.
These monies have not been paid, therefore they have cheated me.
Mm.
Now, my lord, I will just take my notes to the ipso dating event. I think my lord has the dates till the exchange.
Mm. Exchange deed between?
No, there was an exchange deed between the owner and I am accused number 3, I am the purchaser. But I have purchased virtually by exchanging a property. I have purchased these flats, my lord, from the owners. That is the petitioners in serial number 17.
Exchange deed is dated 28/9/2012
Please, madam.
between accused number 1 and 3.
Between accused number 1 and 3.
Yes.
By virtue of this exchange deed, my lord, the liability of the owners, that is the liability to pay BESCOM deposits, VWSSB deposits,
Mm.
and Khata transfer charges was passed on to me.
Yes. You are
Now-
liable to pay.
I was liable to pay.
Mm.
Now, after this purchase, my lord, the developer, that is the complainant, raised a demand of close to 61 lakhs
Mm.
on me. I disputed this amount. I said this cannot be the charges towards BESCOM, VWSSB and transfer of Khata.
Mm.
For each lakh, you cannot charge me 20 lakhs.
Mm.
In fact, my lord, was service tax notice was issued to the complainant.
Mm.
I produced an annexure, that is the complainant himself.
No, whether the complainant has demanded that amount by
Yes,
issuing the
demanded
notice.
the amount from- He had demanded the amount from him, I denied that amount, and I disputed that amount.
The notice was issued to accused number 3 alone,
But they were both the accused,
A1 and 3,
one
dated. Notice is dated.
3/5/2020.
You have issued reply.
But thereafter, I filed a suit, my lord, against
There is no reply.
there is no reply.
No reply either by accused number 1 or 3.
So I am not sure about the accused number 1, my lord, I have not issued any reply.
Why you have not issued any reply?
But what happened, my lord, immediately, I had taken possession of the flats.
Maybe.
Along with this, my lord, the complaint again, earlier a complaint was filed. In that complaint, he does not say anything about cheating. The
Maybe
complaint-
whatever it may be, when you are served with the notice, what prevented you from replying? You cannot receive the notice and keep quiet. Instead, you file a suit.
Yes, my lord, I filed a suit.
OS number?
OS number 6427 of 2015.
suit for?
It was a suit for injunction, my lord, not to interfere with my possession.
That is why criminal complaint was filed.
My lord, in the earlier.
You are not denying the claim, you are not paying the amount.
This amount was first demanded in 2013.
Hmm.
I will
13.
just point out why I disputed the amount. The reason is, my lord, he has, for similar flats, he has taken only about 10 lakhs.
I am
from the
not,
apartment owner.
see, you are at liberty to dispute the liability. Where you have disputed, you have not issued the legal
I am not-
reply.
I am not, but in the suit
From
I-
2013 to 2015, you kept quiet, and suddenly you filed the suit for injunction, got a temporary injunction, and you are satisfied with that. What the complainant has to do?
In that suit, my lord, I had also said
Hmm.
that this demand is not.
Maybe you
justified.
may be saying so, but that prompted the complainant to file the complaint.
So earlier, this is the second complaint.
Hmm.
After 7 years, even he does not say cheating at the first instance. What he does is, earlier there was one more complaint, my lord.
What happened to the suit?
My lord, suit, my lord, ultimately injunction was granted and then I withdrew the suit, my lord, because I've taken possession of the property and withdrew from the suit.
Against?
Against the same complainant against me.
Only against accused number 3,
Please.
crime number?
Sorry.
Sir, you should be ready with the facts.
Earlier, the earlier.
You are searching, everything you are searching.
Page number, I'm sorry, but the earlier complaint is 7th of
Is it the way of addressing the argument? You should keep it handy. Spontaneous ಆಗಿ ಮಾಡ್ತೀನಿ. You will have. Then you ask the court, come to page number so and so, go to page number so and so. Nothing will be found in those pages. And you do not know the facts.
But the earlier complaint.
And unnecessarily, we have to wait. Naturally, sir, no advocate will have only one single brief. You will have multiple cases. So also the court. Then why should I wait? Is it not waste of time? Last time I heard it in part, and still this is the fate. Accountability illa, responsibility illa. God alone should save the clients. Yes, ಏನ್ ಮಾಡ್ಬೇಕು ಇವಾಗ? Straight away I'll dismiss the petition ಅಷ್ಟೇ.
Sometime may be given, my lord.
Again, adjournment.
No, not.
I'll go on, I understood the facts. I understood the situation under which the complainant has filed the complaint. You face the trial. ಏನಿಲ್ಲ. ತಗೊಳ್ಳಿ.
Point out two things. The petitioner in the other case.
Anything, HCGP?
They have issued by receiving the amount and they are not ready to, and they are filing the suit and they are dragging the matter and
Investigation is
investigation not at.
Let the investigation undertake. ತಗೊಳ್ಳಿ. ಎರಡು ಕೇಸ್ನಲ್ಲಿ. Petitioners being accused number 1 and 2 in the criminal petition number 6100 of 2021 and accused number 3 in criminal petition number 3804 of 2020 are seeking to quash the criminal proceedings initiated against them for the offense punishable under sections 417, 420, read with section 34 of IPC on the basis of the private complaint PCR number 53057 of 2020 filed by respondent number 2. Brief facts of the case are that respondent number 2 as complainant filed PCR 53057 of 2020 before The 29th Additional Chief Metropolitan Magistrate, Mayor Hall, Bengaluru, against accused numbers 1 to 3, alleging commission of the offence, punishable under section 417, 420, with section 34 of IPC. It is the contention of the complainant before the trial court that it is a developer under the name and style as Messrs. Keyland Developers. Accused number 1 is the owner of the land, 2 is the wife of accused number 1, and accused number 3 is the subsequent purchaser of the land from accused number 1. It stated that there was a joint development agreement dated 17/4/2008 entered into between accused number 1 and respondent number 2 as per Annexure D. There was sharing agreement between accused number 1 and respondent number 2 as per Annexure E dated entered into on the same date. Accused number 1 executed the registered GPA deed in favor of respondent number 2 on the same day. In spite of that, in spite of that, Synopsis ಏನ್ ಸರ್, ಫ್ಯಾಕ್ಟ್ಸ್ ಹೇಳಲಿಕ್ಕೆ ಗೊತ್ತಿಲ್ಲದೆ ಇದ್ರೆ ಏನ್ ಮಾಡ್ಬೇಕು? ವೆರಿ ಸಾರಿ ಸ್ಟೇಟ್ ಆಫ್ ಅಫೇರ್ಸ್. ಸರ್, ವಾಟ್ ಇಸ್ ಟು ಬಿ ಡನ್ ಹೇಳಿ? ಲಾಸ್ಟ್ ಟೈಮ್ ಅರ್ಧ ಹಿಯರ್ ಮಾಡಿದ್ದೀವಿ, ಇವತ್ತು ಕೇಳಿದ್ರೆ ವೆರಿ ಸೇಮ್ ಸ್ಟೇಟ್ ಆಫ್ ಅಫೇರ್ಸ್. Nobody knows what is the fact. What the court should do? Huh? Is it the professionalism you are showing? I pity for them, the clients who believe the advocates, and ultimately blame the court. Really sorry state of affairs. Not only in this case, each and every case, this is the position. If we say something, it will be made much of. The court is blaming the advocates. Minimum professionalism bedwa, sir. This is not the first day I have taken up the matter. Last time arda hear ಮಾಡಿ adjourn ಮಾಡಿದ್ದೀನಿ. Still the same state of affairs. ಆ ಸೀರಿಯಸ್ನೆಸ್ ಇಲ್ಲ. ಬ್ರೀಫ್ ತಗೊಂಡಿದ್ದೀವಿ, ಮಾಡಬೇಕು, ಇಟ್ ಈಸ್ ಅವರ್ ರೆಸ್ಪಾನ್ಸಿಬಿಲಿಟಿ, ಇಲ್ವೇ ಇಲ್ಲ. Why should the court wait? Sir, apology will not solve any problem, sir. From morning ಇದೇ ನೋಡ್ತಾ ಇರ್ತೀವಿ ನಾವು. ನೀವು ಇಲ್ಲಿ ಮುಗಿಸ್ಕೊಂಡು ಹೋಗ್ಬಿಡ್ತೀವಿ. ನೆಕ್ಸ್ಟ್ ಮ್ಯಾಟರ್ ಸೇಮ್ ಥಿಂಗ್. We are also human beings. ಬೇರೆ ಏನು ಬೇಡ, ಜಸ್ಟ್ ಫ್ಯಾಕ್ಟ್ಸ್ ಹೇಳಿದ್ರೆ ಸಾಕು, ಮುಂದಿಂದು ಆಗೋಗುತ್ತೆ. ಅದನ್ನು ಮಾಡಲ್ಲ, ಸುಮ್ಮನೆ ನಿಂತು ಬಿಡೋದು, ಅದು ಹೇಳೋದು, ಇದು ಹೇಳೋದು. ವೆರಿ ಸ್ಯಾಡ್. ಎಸ್, ಏನ್ ಮಾಡ್ಬೇಕು ಇವಾಗ ಹೇಳಿ?
Kind enough to hear me complete my argument. Already made my sufficient. Dates my lords wanted.
Sheer waste of time, sir. ಇದು ಮತ್ತಿನ್ನೇನು ಇಲ್ಲ. ಇಷ್ಟೆಲ್ಲ ನೋಟ್ಸ್ ಬರ್ಕೊಂಡು ಐ ಆಮ್ ರಿಫ್ರೆಶಿಂಗ್ ಮೈ ಸೆಲ್ಫ್. ಸ್ಟಿಲ್ ಅದರದ್ದು ಏನು ಪರ್ಟಿಕ್ಯುಲರ್ಸ್ ಹೇಳೋದಿಲ್ಲ. ಆ ಯಂಗ್ಸ್ಟರ್ಸ್ ಅಲ್ಲಿ ಯಾಕೆ ಹೀಗಾಗಿದಾರೋ ನನಗಂತೂ ಗೊತ್ತಿಲ್ಲ. ಈ ಪ್ರೊಫೆಷನ್ ಯಾವ ಕಡೆ ಹೋಗ್ತಾ ಇದೆ, ಐ ಡು ನಾಟ್ ನೋ. ಕಮಿಟ್ಮೆಂಟ್ ಬೇಕಲ್ವಾ? They are trained either to seek adjournment or to seek passover. ಅಷ್ಟೇ. File open ಮಾಡಿ facts ನೋಡ್ತೀವಿ. No, nothing. And all are busy, fortunately. At the cost of whose? At whose cost? At whose cost, sir? Clients are the paymasters. They may not be knowing what is going on here. Ultimately, blame the court. Court has not understood. Court has not given the time. Yes.
Dates which my lords wanted.
Give it. The respondent number 2 is the developer. Accused number 1 is the owner of the land. 2 is his wife. 3 is the subsequent purchaser of the land from accused number 1. There was a joint development agreement between respondent number 2 and accused number 1. Yeah, then sharing agreement was also entered into on the same day. And accused number 1 executed the general power of attorney deed. That is the registered general power of attorney deed. None of these documents are disputed.
None of.
Yes.
Subsequently, there was a memorandum of understanding also entered into between the complainant and the accused number 1. That is dated 21/4/2012.
Yes.
That may not.
Why that memorandum of understanding?
Say what happened since the developer could not complete the construction work. The owner started asking the developer that he is not able to continue because he was residing there. He wanted to shift somewhere else where the residence is, and this was under construction and it was not complete. That is the reason he's informed the developer saying that he wants to transfer his undivided right over this particular project in favor of third parties.
Who? Respondent number 2.
Respondent number, accused number 3.
No, why that was entered into?
That was entered into because builder was not able to complete the project.
Yes, he could not develop.
He could not do it. So I said, I can't wait for long. I need some shelter when I'm in India.
You means accused number 3.
So I sign up a memorandum of understanding with the developer.
Yes.
So that is, my lords will find it.
No, that memorandum of understanding enables you to
also transfer the rights in favor of third parties. And if that transfer happens, then whatever dues are there in respect of the BWSSB or BESCOM, the subsequent transferee will be liable. That my lords will find it in page number 27.
So on the basis of such memorandum of understanding, you sold the property in favor of accused number 3.
And this was informed by emails. Those batch of emails are annexure F1s. Annexure.
Why this exchange deed?
Exchange deed is where I transferred my right in favor of third accused, where this property I took and my share I gave it.
So you purchased the house of accused number 3 and accused number 3 took the share of accused number 1 in the project.
And this was pre-informed by emails. These are the bad set of emails which I have produced, communications, which he was aware before the lodging of the complaint. Annexure H series. These emails also are not seriously in dispute.
Annexure,
Annexure H series, H1 and H1 is dated April 3rd, 2012.
H1 is dated.
H1 is date.
November,
H1 is dated
no, November 15.
3/4/2012.
3/4.
Please. This is addressed to the managing director, who is the company, managing director of Skyline Construction.
Oh, how can it be? Your exchange deed is of the September 2012.
Please,
How can the mail be during April?
informing that I am intending to sell it.
Adayitu. Amele, after that,
Subsequently, my lord,
after this exchange deed,
annexure H7, my lord, is September, dated September 2000. That also is 1st September, my lord.
that is also earlier.
First,
Then
subsequently on 27th September 2002, annexure H8,
27/9,
27/9/2012.
H8.
Please. H8,
ಎಲ್ಲಿದೆ ಅದು?
that is 136, in page number 1.
This is sent by?
This is sent from wife, that is petitioner number 2's email.
That
Wife
is
of first accused number.
To respondent number 2.
Please.
Yeah, what is the content?
Contents, my lord, are like this, my lord. Another email points that needs to be added is that you are aware that the maintenance charges, PBW charges will have to be given by you directly. This is also addressed to accused number 3, informing in that you are also liable, you are liable to pay. Would be obliged if you could, based on clause number 8, page number 15, please request the lawyer to draft out the
Letter.
that he will ensure Avinash, developer, will be handed.
Ensuring.
Ensuring that this particular clause is also taken care of. Please note that even in the main document, in this same clause, the lawyer will have to change the date 31/3/2013. This is the context.
No, where it is addressed to the complainant? It is addressed to accused number 3.
Accused number 3. These are the prior informations, remember? Answer. Thank you. Court will find the letter acknowledging the knowledge is dated 3/5/2013, in page number 130. That is not an email, it's on the letterhead of the seller.
Page number?
Page number 130. This, my lord, is addressed by the developer. One is to the purchase, accused number 3, and another is accused number 1.
ಇದಕ್ಕೇನು ಎನೆಕ್ಚರ್ ಏನೋ ಇರಲ್ಲ. ಏನಂತ ರೆಫರ್ ಮಾಡ್ಬೇಕು ನಾನು?
ಇದು ಇದರ ಪಾರ್ಟ್ ಆಗಿ it was attached into H5, annexure H5, so in separately. But this is an admitted document.
Where he is admitted? Who has admitted? Where he has admitted?
This is where he says, he addresses it and says.
This letter is written by?
Written by Skyline developers. That is complaint.
To
Accused number 1 and accused number 3.
What does it say?
In pursuance of the joint development agreement bearing with the supplementary agreement, all dated 17/3/2008, executed between second of you, we are happy to inform that we are in receipt of the occupancy certificate from BBM. Further, we understand that you had entered into a registered exchange deed, so he is aware of it, dated 28/9/2002 with Mr. Mohammed Mazum Aziz, the first party herein, who had stepped into your shoe as the person responsible for your share of apartments, undertaken all the responsibility referred under the aforesaid joint development and sharing agreement. Since we have obtained the occupancy certificate for the project, you are required to pay the service tax and VAT for your share of constructed area. We have also filed an application for obtaining permanent power and water connection to BESCOM and EWSSP, and the copy of the said application is attached herewith. This letter for your reference. Further to the above, you are required to pay us the deposits detailed herein in order to enable us to proceed and obtain permanent power and water connection for your share of constructed area. Next page contains the details of the amounts. The total sum and substance of the complaint, my lord, seems to be that this payment of EWSSB is not being made by accused number 3. So the complainant wants to join me also into this complaint to say that I have cheated. The complaint part, para 7, my lord, page number 37. This content, my lords, will find. Now, not submit para 5, it starts, my lord, the allegation starts at para 5
of the complaint.
Page number 36.
But why accused number 3 is not paying that?
My lord, that is between the accused number 3 and then.
You are for accused number 1 and 2 only.
1 and 2.
You are for accused number 3. You have no explanation.
Please.
He has similarly, we have 3 other flats, 3 flats were sold to me. In this share, there are 3 flats. He has sold these 3 flats to purchasers. He has collected roughly between 10 lakhs to 12 lakhs from the purchasers of those 3 flats, which are identical to my 3 flats. So I said, you are raising 22 lakhs remand on me.
Where you raised the dispute?
No, I filed the suit.
You have not issued any reply.
I have not replied, but
And you filed the suit,
I filed the suit.
got the interim order,
Yes, in that.
and you are satisfied. And you withdraw the suit subsequently. Since the purpose is served, you withdraw the suit. Where you raised a dispute with respondent number 2. Have you have not issued any reply to this? 5th May 2013.
What's kind of submission, so the one submission which I tried to make it. All of us are made party and a CMP is filed. Since there is an arbitration clause in the joint development agreement. section 11(6) is invoked and arbitrator is sought to be appointed. Before this court, it is pending now. Received notice and filed Vakal, CLP 363/2024.
Who is in possession of the apartments? Then now you are in possession, so you are not paying anything. You are also not disputing that. You are squatting over the property. Is it not necessary to raise that dispute in writing when a specific demand is made by respondent number 2? The moment you have not issued any reply, that amounts to admission of your liability. Where you yourself is disputing, but never communicated to respondent number 2. No, I think.
Earlier a complaint in 2015, this is the prior complaint in respect to the same subject matter. There he does not say anything about cheating.
Yes.
So this is only an afterthought. Now after 7 years, he says cheating. That is my first submission.
Which is your petition? Your contention is same.
Same, saying that
There is a transfer of liability. There is transfer of liability.
As on the date of signing of these agreements, my lord, there was no intention to, the allegation is at
That
the
is there.
inception, it is
Yes.
not there.
And if at all, accused number 3 is liable to pay.
He is liable to pay, which is a subject matter of CMP before, once arbitrator is appointed, it will be taken care of with the arbitration proceeding, which now is pending before this honorable court.
Who instituted arbitration proceeding?
Same there, complaint. Well, I pass on copy of that law. Pass. All these agreements, joint development, everything is a part of it. Including
What is the dispute there?
There, same amount, recovery.
Early there.
For appointment of arbitrator to resolve this.
Whether appointed?
No, not, it is still pending. We have received notice, we have filed our order. That's it.
Yes.
That's-
Anything? Which is that complaint? 7th of August of this complaint. This complaint. No, this complaint is dated.
This complaint is dated 24/7. So 14/7/2020.
What happened to the earlier complaint?
So the earlier complaint was there was no allegation of cheating. Those the statements were made that the money is due. No
The
allegation.
FIR was registered in crime number. Crime number
The earlier crime number 610
61.
2015.
What that is for the offense?
For the offense 506.
506.
506.
No 420.
So 422.
ಎಲ್ಲಿದೆ ಅದು FIR ಎಲ್ಲಿ?
And complete in my page 115 number.
ಒನ್ 115 ಏನೋ ಬೇರೆ ಇದೆ.
This is complaint. The FIR is follow 120. Page 115. Complaint is 7/15.
ಯಾವ್ದ್ರಲ್ಲಿ ಇದು?
3804/22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22
Where is the order? It is quashed because 155(2) is not compliant.
Then subsequently, the same complaint made an FIR only on 5 marks. On that count, but there is also an observation regarding this contention of the rescom charges and legal charges which are not paid.
That civil suit is already withdrawn.
Now because then now this is only purely a civil matter, not
From your conduct, it reveals that you had the intention of cheating.
they also have intention of paying. But provided you demand the same amount that you demanded with the other purchase.
No, sir. I
You cannot
do not
demand
see any
all
merits in
the
contention.
amount. I just point out one more document. My lord, may kindly see page 113.
One.
In that, they are giving a breakup of what is the.
Sir, you need not have to tell me. Please understand my point. If at all you have to raise the dispute, you have to raise the dispute with respondent number 2. You never issued any reply. You never raised any dispute with him, disputing the quantum of the amount demanded by respondent number 2. You simply not paying the amount. When he started demanding, you file a suit, got the temporary injunction, and you are satisfied with that, and got quashed the complaint earlier filed by the respondent number 2. And after quashing, you are withdrawing the suit. If it is not the cheating, what else it is? Why you withdrew that? You should have contested. You should have prosecuted. Naturally, he is bound to interfere when you have not paid the amount.
Demand the same amount, then I am bound to pay. I was paid.
Yes, understood.
Demand an exorbitant
Yes.
amount, then I am not liable to pay.
This is the case of 420, my lord, and he should return the amount, my lord. And also, my lord, he has simply dragged the matter, my lord, and the investigation is yet to be completed, my lord. By the virtue of the interim order, the investigation has been stalled, my lord, and hence The interim order may be vacated and
Is there contention regarding accused number 1 and 2?
totally they all have deceived the complainant, my lord.
See,
Yes, my lord.
now he has pointed out that letter,
Yes, my lord.
where a letter issued by respondent number 2,
Two,
referring to the exchange deed
the
and
exchange.
the liability of accused number 3.
Yes, my lord.
Then when the liability is passed on to accused number 3,
Three.
where is the liability for accused number 1 and 2?
There is no liability, my lord.
Prima facie, there is no.
Prima facie, there is no liability.
The
Actual
criminal proceedings against accused number 1.
1 and 2, and in respect of 3, it may be
So,
taken.
ಏನ್ ಬಂತು? Land apartments from accused number 1. He purchased the apartments. Accused number 3 purchased the apartments.
Along with undivided share.
3 apartments.
Yes, ma'am.
3 apartments from accused number 1. Eight. 2008. Next. It is the contention of the petition that since respondent number 2 could not develop the land as undertaken under the joint development agreement, accused number 1 entered into a memorandum of understanding with the respondent number 2 as per annexure F dated 21/4/2012 to enable accused number 1 to transfer his right in favor of a third party. As per terms of memorandum of understanding, accused number 1 was entitled to sell his share in favor of third party. And accordingly, accused number 1 entered into an exchange deed, registered exchange deed with accused number 3 dated 28/9/2012. The same is produced as per annexure G. As per the terms of exchange deed, accused number 1 took the house of accused number 3, and in turn accused number 3 took the share of accused number 1 in the project under a memorandum of understanding. It is the contention of respondent number 2. Accused number 1 was liable to pay AEB and BWSSB charges as agreed under a joint development agreement, which is quantified as rupees 66,76,173. The same is not being paid by accused number 1 to 3. They were having the intention to cheat the complainant. Therefore, file the private complaint alleging commission of offence punishable under section 417, 420, read with section 34 of Act. The learned magistrate referred the matter for investigation, and accordingly the FIR in crime number Is it the crime number, the present one? No FIR was registered?
Crime number 77/21 in the first petition month. In first petition. Crime number 77 of 21 in first petition.
77 of. Hello, same FIR all against all the three.
Yes.
Sorry, then crime number 77 of
21 mile.
of which police station?
Ashok Nagar Police.
Ashok Nagar Police Station. In the meantime, the petitioners being accused number 1, 2, 3 have approached this court seeking to quash the criminal proceedings initiated against them. Heard so and so. Then a counsel for accused number 1 and 3, 1 and 2. In the criminal petition number 6100 of 2021, contended that the petitioners are accused number 1 and 2. Accused number 1 was the owner of the property. He entered into joint development agreement with respondent number 2. Sharing agreement and the registered GPA deed was also executed on the same day as per annexure D, E, D and E. Accused number 1 entering into exchange deed. Sorry. Accused number 1 entering into memorandum of understanding with respondent number 2 as per annexure F dated 21/4/2012 is an admitted fact. He has drawn the attention of the court to the letter dated 3rd May 2013 addressed by respondent number 2 to accused number 1 and 3, calling upon them to pay the service tax, VAT of their share of constructed area, and also to pay BESCOM and BWFSP charges quantified as rupees 56,76,173. The complainant called upon accused number 1 and 3 to pay the said amount within 7 days, or else cautioned them that they are liable to pay interest at 24% as penalty. Next, learned counsel for the petitioners, accused number 1 and 2, submitted that when respondent number 2 refer to the memorandum of understanding and transfer of the rights and liabilities of accused number 1 to accused number 3 under the exchange deed, accused number 1 and 2 are not at all liable to pay any amount, and under such circumstances, the offense under section 417 and 420 of IPC is not at all made out against them. Accordingly, it pays for allowing the petition. Then next part, counsel for the petitioner in so and so other matter. So 7804 of 2020, being accused number 3, contends that even though entering into the documents between accused number 1 and 3, that is joint development agreement, sharing agreement, and the registered GPA deed dated 17/4/2008 are not disputed. Execution of the memorandum of understanding between accused number 1 and 2 dated 21/4/2012 as per annexure F is also not in dispute. Pursuant to the same, there was exchange deed between accused number 1 and 3 dated 28/9/2012, upon which accused number 3 took the share of accused number 1 in the project under memorandum of understanding. Then the counsel admit that accused number 3 is liable to pay electricity and BWSSP charges to respondent number 2 as agreed under joint development agreement. However, he disputes the amount, the quantification of the amount claimed by respondent number 2. Since there is a serious dispute about the quantum of amount that is payable by accused number 3, it cannot be said that the accused number 3 was having any intention to cheat. Therefore, he prays for allowing the petition by questioning the therefore. Then a counsel further submitted that a similar complaint was filed by respondent number 2, alleging commission of the offense under section 506 on 26/7/2015. FIR was to be registered against accused number 1 and 3. Along with other persons. Accused number 3 had approached this court by filing criminal petition the criminal petition. The page number. (1261) of 2017 before this court. This court, after considering the contentions taken by the parties, allowed the petition and quashed the criminal proceedings that was registered for the offense under section 506 of IPC in CC number 56911 of 2016. And thereafter, belatedly, during 2020, the present complaint was deemed to be filed without any basis. Hence, he pays for allowing the petition. Per contra, and HGP for the state opposing the petition submitted that serious allegations are made against the accused by respondent number 2. Admittedly, respondent number 3 has not paid the amount towards KEB and BWSSP charges after agreeing to pay the same, and it is a clear case of cheating. The investigation is not undertaken by the investigating officer in view of the interim order of stay granted by this court. The investigation in the matter would reveal the true facts, hence he prays for dismissal of the petitions. Here used materials point for consideration my answer to their point, partly in the affirmative for the following reasons. Next, the facts of the case that accused number 1 was the owner of the land, accused number 2 is his wife, and accused number 2 was his wife is not in dispute. It is also not in dispute that respondent number 2, being the builder, had entered into joint development agreement with accused number 1 on 17/4/2008, agreeing to develop the property. Sharing agreement of even dated was also entered into between accused number 1 and respondent number 3, which is as per Annexure E. Admittedly, a registered GPA deed was executed by accused number 1 in favor of respondent number 3 on the very same day. These documents are admitted by all the parties. Next part. It is the contention of accused number 1 and 2, accused number 1, that since respondent number 2 could not develop the property as agreed under JDA, a memorandum of understanding was entered into between accused number 1 and respondent number 2, whereunder accused number 1 was authorized to transfer his right in favor of third party. The said agreement memorandum of understanding is produced as per Annexure F. As per terms of MOU, A1 was entitled to sell his share and in such event, either accused number one or the subsequent purchaser was liable to pay the maintenance charges, electricity and PEB, electricity and BWSSP charges in respect of the upper apartments while taking possession. Then the counsel for accused number one has drawn my attention to the letter dated 5th May 2013, addressed by accused number two, respondent number two, to accused number 1 and 3, wherein there is reference to the registered exchange deed dated 28/9/2012, and it is stated that accused number 3 had stepped into the shoes of accused number 1, and thus accused number 3 is liable to pay service tax, VAT, KEB and BWSSP charges, and he quantified it as at rupees 56,173. When the respondent number 2 categorically admits accused number 1 and 3 entering into exchange deed, and accused number 3 entering into the shoes of accused number 1, the liability to pay the amounts claimed by respondent number 2 is on accused number 3. But however, the complainant is claiming the amount from accused number 1 and alleging cheating against accused number 1 and 2. In the light of these admitted facts and circumstances, when respondent number 2 admits entering into exchange deed between accused number 1 and 3, and categorically states that accused number 3 entered into the shoes of accused number 1, I do not find any merits in the contention taken by respondent number 3 that accused number 1 is still liable to pay any amount, and he had an intention to cheat the complainant. Therefore, the registration of the FIR, filing of the complaint and registration of the FIR against accused number 1 and 2 is liable to be quashed. Next. In view of the facts and circumstances narrated above, it is clear that accused number 3 purchased the share of accused number 1, and it is stated that accused number 3 has already taken possession of 3 apartments and he is in possession of the same. But in spite of that, he has not paid VAT, GST, service tax, VAT, DESCOM and BWSSP charges, which was undertaken to be paid while taking possession of the property. As per the letter dated 3rd May 2013 referred to above, respondent number 2 has addressed a letter to accused number 1 and 3 calling upon them to pay the amount of rupees 56,76,173. Admittedly, accused number 3 has not replied to the same. He never raised any dispute about the quantum of the amount. However, he has not paid it. On the other hand, when the complainant has filed the complaint, filed the first information on 7/8/2015 against accused number 3, and the FIR in crime number 610 of 2015 was came to be registered, 610 of Ashok Nagar Police Station was came to be registered for the offense punishable under section 506 of IPC. He appears to have filed the suit OS number 6427 of 2015, seeking permanent injunction against respondent number 2. Pursuant to the same, criminal petition number 1261 of 2017 came to be filed before this court seeking quashing of the criminal proceedings. The coordinate bench of this court, considering the merits of the case, found that the offense alleged is a non-cognizable offense and the procedure under 155(2) of CRPC was not followed. It was also found by the coordinate bench that accused number 3 herein, the petitioner in the said petition had filed the suit was 6427 of 2015 seeking permanent injunction, and therefore the criminal proceedings was came to be quashed. Interestingly, after quashing the criminal proceedings by allowing criminal petition number 1261 of 2017, the said civil suit was 6427 of 2015 is not pressed by accused number 3. Here, the conduct of accused number 3 is to be taken into consideration. Admittedly, he purchased the share of accused number 1 and he is liable to pay service tax, VAT, VWSSP, and the KB and VWSSP charges. Admittedly, the said amount is not paid. He admits receipt of the notice from accused number 2 demanding payment of the amount. Admittedly, no reply was issued by accused number 3. It is also admitted that accused number 3 is in possession of 3 apartments. The suit was 6427 of 2015 was filed seeking permanent injunction against respondent number 2 from interfering with the possession of accused number 3, who was successful in getting the getting temporary injunction, and later the suit was not prosecuted and the suit was withdrawn. Thus, accused number 3 has never raised any dispute with regard to the claim made by respondent number 2, but at the same time, he took possession of the property, was squatting over the same without paying the amount. Thus, prima facie, the intention on the part of accused number 3 to cheat respondent number 2 is very clear. Hence, criminal proceedings initiated against him is not liable to be quashed. Accordingly, I propose to dismiss criminal petition number 3804 of 2020 while allowing criminal petition number so and so. Accordingly, I answer the point partly in the affirmative and proceed to pass the following. Criminal petition number 6100 of 2021 filed by accused number 1 and 2 is allowed. Criminal proceedings so and so quash. Criminal petition number 3804 filed by accused number 3 is dismissed. Yes, partly allowed. 3804 is dismissed.
Obliged.
Serial number 23, M. Shivaprakash, Kumara KG.
23. Huh? 25 ಆಗಿದೆ. ಆಯ್ತಾ? Okay.
My lord,
Yes.
I represent Fitzgerald. That a brief chronological dates and scenarios.
Who is the petitioner?
A1.
Petitioner is A1.
Petitioner is A1 man.
In all, how many accused are there?
One other accused, A2.
What are the offense alleged?
My lord, offenses accused is that 406, 417,
420.
418, 420, that is section 34.
3 accused, your lordship.
3 accused, 1 accused is discharged.
Who is discharged?
before the Honorable District Judge in Mysore, my lord.
Who is discharged?
One Shailaja,
Accused number?
A3 is.
A3. My lord, in nutshell, brief facts of the case is this petition before my lord. He is the owner of a residential house in Jayalakshmipuram in Mysore. It is measuring about 60 feet east-west and 110 feet north to south. My lord, this petitioner was a nuclear engineer in the department and he served for more than 35 years. There is unblemished career in his profession. My lord, one of his daughters, she got graduation and she now working in America. Now both parents, aged parents, they want to go and join with their daughter. At that time, this proposal was made to sell this property. Then one developer by name Shwok Kumar, under the name and style that Balaji Developers, he has come and he has entered into this sale transaction of memorandum of agreement and MOU on 12/8/2013. My lord, on 14/9/2016, the entire property has been sold to the very same builder, that is Shwok Kumar. On 14/9,
Memorandum of understanding, what is the undertaking?
memorandum of understanding what payment of amount of 1 crore and 19 lakhs. And after that, these persons were in a hurry to go and join their daughter because they are the only two persons in Mysore in their house. Nobody was there to look after. So the daughter demanded
No, under the memorandum of understanding, developer has to pay 1 crore. to the
1 crore and
petitioner.
add. 1 crore and add is amount, my lord,
To the petitioner,
to the petitioner.
and he has to develop the property.
He has to develop the property.
Then,
That amount also he has not paid, only part of the consideration he has paid. And he went on saying that he want to obtain certain permissions from the MODA and other necessary permission. He prolonged it. Then on 14/9/2016, an absolute sale deed has been executed in favor of this builder. And these persons, they went to join their daughter in America.
yes.
Now, this developer in between, he has also earlier obtained this power of attorney and he did some transaction here in Mysore. My lord, on 21/5/2015, yeah, on the item number 4, my lord, item number 4. He has entered into transaction with one individual, Mr. Anand, to sell ground floor 1 flat to him for a consideration of 31 lakh.
No, flat was built by,
My lord,
flat was built by,
by the builder, that
A2.
Shwok Kumar, A2. He is a builder. He call himself as a contractor. He call himself as a person who involved in this real estate to purchase all these properties. The whole and sole responsibility is on the builder to build and complete the constructions. My lord, with this Anand on 21/5/2015, he has entered into an agreement and the time duration for completion of that agreement was 9 months between Anand
means developer entered into an agreement
with
with
Anand.
Anand.
And the time duration for completion is 9 months.
And accused one also, your lord. As per sale agreement, accused one is also a party.
What was the agreement?
Agreement was on 21/5/2015. After this, my lord,
No, what are, as per the terms of agreement, what is to be done?
31 lakhs is the sale consideration. And within 9 months, the construction is to be completed and it is to be handed over to this Mr. Anand.
That is much before your sale in favor of builder.
My lord, much before, because 13 was his MOU and agreement, whatever he want, he has taken all those records from my side and he has entered into these transactions.
So both the builder and accused number 1 entered into agreement with
This
Anand?
agreement, he got my signature also on this agreement of Mr. Anand. Because I was, so for a few months, I was here, at that time he has obtained all these documents. I, myself and my wife were with my daughter in US.
Registered sale agreement.
It's a register. My lord, this, by virtue of this agreement, Mr. Anand has paid rupees 30 lakhs a check in favor of Shivakumar individually.
Shivakumar is a developer.
He is a developer. Done in the Bank of Mercantile Credit Cooperative Society, Mysore.
Yes.
Well, afterwards, he has extended some lame excuse and he has postponed in my absence because I was, once in a way I was coming here and I was going back. He has extended by saying that I have to come from abroad and only when I reach here in Mysore, then only I can proceed with the matter. That's what the assurance given by this Shivakumar to Mr. Anand. Then, my lord, because the time was also elapsed and this Mr. Anand has filed a original suit for specific performance.
Yes.
This suit is OS 87 of 2018 on the file of humble senior civil judge and CJM Mysore. This suit was filed on 17/1/2018, but here it is typed as 18, my lord. On verification, it is 17/1/2018.
Yes.
In the suit, he has arraigned me also as a defendant. Number one, because as a owner, he has arraigned me. I filed my detailed return statement also asserting that the entire thing of contractual obligation is by this Shivakumar, a builder and a promoter or a contractor and a real estate agent who has to complete his contractual obligation. But the second defendant, as per the records till date, he has not filed his return statement, is the information. Then, this is in the month of January 2018. My lord, after completion and after issue of notice and process by the humble city, the civil judge in senior civil judge in Mysore, then this thought of filing this criminal private complaint. The private complaint is filed on 1/3/2018
By Anand.
by Anand.
Against
Me, arraigning me as accused number 1 and against the builder.
Accused number 2 is the builder. Who is accused number 3?
Accused number 3 is subsequently this gentleman, this.
In 2017, sale deed was registered in the name of A3 for the same property schedule.
Same property says that ground floor. When I came from America, all of a sudden he said everything is ready, you come and sign and you please short period. He got the signature also. Then that document has been registered. On 1/3/2018, this complaint was filed, my lord.
What happened to the suit?
My lord, suit is now as it is, trial is going on, evidence of the plaintiff is completed.
Your lordship, sale deed date is 22/9/2017.
Sale deed?
22/9/2017 in favor of A3.
One more. Sale deed dated?
22/9/2017. Here A2 is not a party.
Only accused number 1 executed. Then very good question, sir.
Yes. Now, as it is, the whole and entire thing is on the contract, this builder. Now, when I visited India and my native place, Mysore, this person said everything is ready. You have to
Cannot go on pleading that, sir.
No, that.
On record, it is the accused number 1 who executed the sale deed. When the suit for specific performance was pending.
Suit for specific performance was filed
18,
thereafter,
madam,
Your
18,
After.
18.
Ah,
It was 18.
Yes, 2017
appears that-
sale deed.
Here is
17,
2018.
Yes.
this 17, the so-called the Shivkumar, he is person who got all these transaction because I was not actually participating because of my age and also when I visited Mysore.
If at all, you have to file a complaint against this.
Shivkumar.
This
Developer.
Shivkumar.
First.
And now as it is, this specific performance is that the sale deed has been executed, that it is not now, as it is agreement, he is holding agreement is holding for that in that agreement, it is the time period is 9 months. Even that 9 months of the year 2015 is elapsed. Now on merits, it has to be decreed or it has to be finally adjudicated. Now meanwhile, what is my intention and whether I have any intention of, because all along he says in the private complaint, my lord, page number 11 is his complaint. My lord, may I kindly take my lord to internal page number, ink page number is 13. From the agreement of sale dated 21, the page number 12 is the last but second line, my lord. That paragraph 5 I am reading, my lord. Agreements of sale dated 21/5/2015 in favor of the complainant agreeing to sell G1 flat on the date of said agreement for sale with consent of first accused. The complainant has paid rupees 30 lakh to the second accused. Second accused is this builder. Towards advance sale consideration amount by way of check bearing number so and so drawn on the Mysore Merchants Cooperative Bank Limited. Further, it was agreed that the accused number 1 and 2 shall execute the sale deed, conveying in favor of the complaint within 9 months from the date of agreement for sale. Further, it was agreed that the accused number 1 and 2 shall provide information with respect to the progress of the construction to the complainant. Complaint submits that immediately after the lapse of 9 months from the date of above said agreement, complainant has approached a second accused and demanded for the execution of the sale deed in favor of the complainant. At that juncture, the second accused has informed the complainant that first accused has been to abroad and he will be returned only during the month of August 2016. As such, request the complainant to wait till the arrival of the first accused in order to execute the sale deed. Believing the words of second accused, all along in the complaint, the second accused has taken a major role and a vital role. Being a contractor and being a builder, the person who has actually in Mysore and he has taken a major role and vital role and important role in the to say communication with this agreement holder. Now he has also taken 30 lakhs from the complainant, Malad. In his name only this check is issued.
Yes.
Check is issued.
Yes.
Everything he did, and finally a civil matter where these two persons are now landed in the court for execution of sale deed, they have converted the civil dispute into say criminal case. I being the innocent and I have been implicated, and even that the document which he has got from my side when I came and visited my native place, this is the mischief he has created. The second accused, the builder. He is the root cause for all these things, my lord.
Investigation.
My lord, charge sheet is submitted. Charge sheet is submitted. My lord, charge sheet is at 24.
Read column number 17.
ಜಯಲಕ್ಷ್ಮೀಪುರಂ ಪೊಲೀಸ್ ಠಾಣೆಯ ಸರಹದ್ದಿನಲ್ಲಿ ಜಯಲಕ್ಷ್ಮೀಪುರಂನಲ್ಲಿರುವ ಮೈಸೂರು ನಗರ ದೇವರಾಜ್ ಮೊಹಲ್ಲಾ ಜಯಲಕ್ಷ್ಮೀಪುರಂ 5ನೇ ಮೇನ್ 25ನೇ ನಿತ್ಯೋದಯ ಎನ್ಕ್ಲೇವ್ ಅಪಾರ್ಟ್ಮೆಂಟ್ನ ಫ್ಲಾಟ್ಗಳ ಪೈಕಿ ಫ್ಲಾಟ್ ನಂಬರ್ G1 GF 1029 ಅಡಿಯ ಸೊತ್ತನ್ನು ಆರೋಪಿ 1ರಿಂದ ಸಾಕ್ಷಿ 1 ಅವರು 31 ಲಕ್ಷ ರೂಪಾಯಿಗಳಿಗೆ ಕ್ರಯ ಪಡೆಯಲು ಒಪ್ಪಿ 30 ಲಕ್ಷ ರೂಪಾಯಿಯನ್ನು ಸಾಕ್ಷಿ 1 ಅವರು ಮುಂಗಡವಾಗಿ ಬಾಲಾಜಿ ಬಿಲ್ಡರ್ ಆದ ಆರೋಪಿ 2 ಅವರಿಗೆ ಚೆಕ್ ಮೂಲಕ ಹಣವನ್ನು ಕೊಟ್ಟಿದ್ದು, ಆರೋಪಿ 1 ಮತ್ತು 2 ಅವರು ಅಪಾರ್ಟ್ಮೆಂಟ್ ಕಟ್ಟಡದ ಕೆಲಸ ಮುಗಿದ ನಂತರ ಫ್ಲಾಟ್ 1 ಅವರನ್ನು ಸಾಕ್ಷಿಗೆ ಕ್ರಯ ಮಾಡಿಕೊಡುವುದೆಂದು ಹೇಳಿ ದಿನಾಂಕ 21/5/15 ಸಾಕ್ಷಿ 3 ಮತ್ತು 4ರ ಸಮಕ್ಷಮ ಆರೋಪಿ 1 ಮತ್ತು 2 ಅವರು ಸಾಕ್ಷಿ 1 ಅವರಿಗೆ ನೋಂದಣಿ ಕಚೇರಿಯಲ್ಲಿ ಸಾಕ್ಷಿ 4 ಅವರು ಕ್ರಯ ಪತ್ರವನ್ನು ಮಾಡಿದ್ದು, ಸರದಿ ಸೊತ್ತನ್ನು ಆರೋಪಿ 1 ಮತ್ತು 2 ಅವರು ಸಾಕ್ಷಿ ಅವರಿಗೆ ನೀಡದೆ ದಿನಾಂಕ 22/9/17 ಆರೋಪಿ 1 ಮತ್ತು 2 ಅವರು ಸಾಕ್ಷಿ 5, 6 ಅವರ ಸಮಕ್ಷಮ ಆರೋಪಿ 3 ಅವರಿಗೆ ನೋಂದಣಿ ಕಚೇರಿಯಲ್ಲಿ ಕ್ರಯ ಮಾಡಿ ಸಾಕ್ಷಿ ಇಂದ ಹಣ ಪಡೆದು ಮೇಲ್ಕಂಡ ಸೊತ್ತನ್ನು ನೀಡದೆ ಮೋಸ ಮಾಡಿ ನಂಬಿಕೆ ದ್ರೋಹ.
That was 21/5/2015 is the agreement for sale.
Agreement for sale. Registered agreement for sale.
Yes.
Where A2 is also a party.
If I have any active role in participation all along, my lord, and if I have any intention, and if I participated, did all these things, then I should be held responsible. Now, this builder did all this mischief and I am innocent person. When I visited India and Mysore, my lord.
No, it is a matter for trial. Since you have executed the sale in favor of a third party.
My execution is the same thing with this fellow as manipulated and
Then tagoli, a defense you can
like
take.
so they
before the
are
trial.
one small humble request is these aged person because of
Sir, Adana, you cannot go on
No, no.
telling.
these
I respect his age, but the fact
these
is,
persons
remains
even they are holding green card, it has been cancelled because of this
sad state of affairs. ಏನ್ ಮಾಡೋದು? ತಗೊಳ್ಳಿ.
ಅಲ್ಲ ಒಬ್ಬ ಬಿಲ್ಡರ್ ಇಂದ ಈ ರೀತಿ ಆಗಿರೋದ್ರಿಂದ
No, no, no. You proceed against the builder. You file a complaint against the builder. Have you filed any complaint? No.
ನನಗೆ updated information ಇಲ್ಲ.
ಇಲ್ಲ. Petitioner being accused number 1 in CC number 115 of 2018 of which police station?
Jayalakshmipuram police station, Mala.
On the file of Learned First Additional Senior Civil Judge in JMFC, Mysore, is for the offence punishable under section 406, 417, 418, 420, read with section 35 of IPC, is seeking to quash the criminal proceedings initiated against him. The facts of the case are that respondent number 2 filed the private complaint in PCR 8 of 2018 against accused numbers 1 to 3, alleging commission of offence punishable under section so and so so and so. It is alleged by the complainant that accused number 1 is the owner of the property. He entered into a memorandum of understanding with Messrs. Balaji Developers on 12/8/2013. On 21/5/2015, accused number 1 and 2 jointly executed a registered agreement for sale in favor of the complainant, agreeing to sell the property in favor of the complainant for a consideration of rupees 30 lakhs. The said amount was paid by the complainant through check in favor of accused number 2. But thereafter, accused number 1 and 2 have not sold the property in favor of the complainant. But in the meantime, accused number 1 executed a registered sale dated 22/9/2017 in favor of accused number 3. Thereby, accused number 1 and 1 to 3 have committed the offence. Accordingly, the investigation was undertaken and the charge sheet came to be filed by the investigating officer. Trial court took cognizance of the offence and registered CC number so and so, which is pending for consideration. In the meantime, the petitioner being accused number 1 is seeking to quash the criminal proceedings initiated against him. Third, learned counsel for the petitioner and learned HCP for respondent state. And counsel for respondent number 2 is absent. has not addressed his argument is taken as nil. Review the materials, point for consideration, my answer to the above point in the negative for the following reasons. As per the contentions taken by the parties, and I'm going through the materials on record, it is found that petitioner accused number 1 was the owner of the property. He appears to have entered into a memorandum of understanding with accused number 2, who is a builder, on 12/8/2013, agreeing to develop the property. Later, on 21/5/2015, admittedly, accused number 1 and 2 have executed a registered agreement for sale in favor of the complainant, agreeing to sell the property in his favor for rupees 30 lakhs, agreeing to sell the property in his favor, and consideration amount of rupees 30 lakh was paid by the complainant to accused number 2. Even thereafter, the sale deed was not executed. However, it is the specific contention of the complainant that on 22/9/2017, accused number 1 sold the very same property in favor of accused number 3, and thereby accused number 1 to 3 have committed cheating. Materials on record prima facie discloses that accused number 2 was not a party to the sale deed dated 22/9/2017, whereas it is executed by accused number 1 as the owner of the property. Accused number 3 is the subsequent purchaser under the sale deed, under the said sale deed. In the meantime, complainant had filed, it is thereafter the complainant filed the suit was 87 of 2018 seeking specific performance of the contract, which is said to be pending before the learned civil judge. He has also filed the criminal complaint alleging cheating. After investigation, the investigating officer has filed the charge sheet. Prima facie, accused number 1 and 2, after entering into a registered agreement for sale dated 21/5/2015, sold the very same property under the registered sale deed executed by accused number 1 in favor of accused number 3. Under such circumstances, the contention of the learned counsel for the petitioner that petitioner is innocent and he has not committed any offense cannot be accepted at this stage. The contention of the learned counsel for the petitioner that accused number 2 has cheated, accused number 2 being the builder has cheated the petitioner, and accused number 3, accused number 2, the builder cheated accused number 1, and also the complainant cannot be accepted. Admittedly, accused number 1 has not initiated any action against accused number 2. Under such circumstances, I am of the opinion that it is not a fit case for crashing the criminal proceedings. Accordingly, I answer the above point in the negative and proceed after. Petition is dismissed. Petition is.
One submission, take into consideration their age and health. No, only the one sentence is for expediting and dispose. Only one sentence.
ಎಲ್ಲಿ ನೀವೇ ಇಷ್ಟು ದಿನ ಇದು ತಗೊಂಡಿರಿ ಇಂಟ್ರಿಯಂ
ಇಲ್ಲ ಅದೇ ಅಂದ್ರೆ ಬಂತು
In the summons stage, your lordship.
for their lordship several times it has been listed because of other cases it did not reach one. One sentence only so that their age and health to be taken into
It is
consideration.
stated that petitioner accused number 1 is now aged
Is 87 years.
87 years. The criminal case is pending. Criminal case is of the year CC number ಎಷ್ಟು ನೋಡ್ಕೊಳ್ಳಿ. So
115 of 2018.
18.
hence trial court is directed to expedite the matter. Yes.
Please, man. Oblige, man.
Serial number 24 urgent 25 Anaga S Desai.
My lord, the petitioner is a doctor by profession, my lord. The case of the respondent number 2 is that.
Minute, 1 minute. No, earlier you approached this court and suffered an order.
My lord, I was not present on the date on which the.
So you are filing second petition.
My lord, it is only on the additional grounds that I have filed the second.
No. When the case is disposed of on merits, how can you file the separate petition?
My lord, there is a merit in the case that I want to argue on, my lord.
That does not mean to say that you can file a second petition. When on merits, your earlier petition was disposed of. No, on maintainability, it has to be dismissed.
My lord, my only submission is that accused number 1 and 2 have been accused.
And then you seek the legal opinion from any senior advocate. You cannot file, you cannot maintain. Third, learned counsel for the petitioner and learned HCGP for respondent number 1 on maintainability of the petition. The petitioner, being accused number 3, filed the present petition seeking quashing of the criminal proceedings pending against him in SC number 46 of 2017, pending on the file of the learned 4th Additional District and Sessions Judge Mysore, and to quash the criminal proceeding. Quash the criminal proceedings so and so. It is brought to the notice of the court that the petitioner, accused number 3, had filed a similar petition, that is criminal petition number 1011 of 2018, seeking similar relief to quash the criminal proceedings in SC 46 of 2017, pending before the learned 4th Additional so and so.
My lords, I may be permitted.
Petition came to be dismissed on merits with an order dated 7th January 2025. Immediately thereafter, the present petition came to be filed on 22/1/2025 with similar prayer. In view of the above, the present petition does not survive for consideration. Is not maintainable and not survive for consideration. Hence, petition dismissed. Yes. ಫೈಲ್ ಮಾಡೋ ಮೊದಲು ಒಂದು ಸ್ವಲ್ಪ ಅಪ್ಲಿಕೇಶನ್ ಆಫ್ ಮೈಂಡ್ ಬೇಕು, ಒಂದು ಸ್ವಲ್ಪ ಕನ್ಸಲ್ಟ್ ಮಾಡಬೇಕು, ಸ್ವಲ್ಪ ಇನ್ವೆಸ್ಟಿಗೇಟ್ ಮಾಡಬೇಕು, ಸ್ವಲ್ಪ ರಿಸರ್ಚ್ ಮಾಡಬೇಕು.
We consulted a lot of people
And
then filed the second petition, my lord.
No, not maintain. When on merits it is already disposed of, you have other remedy. I am not giving any opinion,
Please,
but not this.
please.